Morning. Microphone's not working. Yes.
My Lord, I have a prayer for listing of a bail application on Monday, my Lord.
All right.
Obliged, ma'am.
May I please, your Lordship?
Yes.
I am praying for listing of a BA, my Lord, on Monday, my Lord.
Yes.
My Lord, another prayer, my Lord, in connection with item number 68, my Lord, we have filed an additional affidavit, my Lord, that may be called for
All right.
with the case check. Obliged.
Next.
May I please, Lordship? Lordship, I beg to mention item number 13 may be urgent today.
Item number?
13. 1-3.
Item 13.
Motion matter. You are Mr.
Yes, ma'am. On behalf of ATM Hussain.
On behalf of
ATM Hussain.
item 13,
1-3.
criminal petition.
No, AB.
So this is pertaining to this honorable court, court number 20, original court number 27.
27 court number.
My Lordship is taking up also the matter of.
Okay. All right, very well.
Court number
In item number 13, which is of the original Code 27 list, AB 383/2024.
After 1 week.
As prayed for by Mr.
Yes, ma'am.
A. Islam, learned counsel for the petitioner, lists this matter after
1 week.
1 week on a date to be fixed by the registry.
Obliged.
May I please, Your Lordship? Prayer for listing of an AB on Monday, Your Lordship.
All right.
Obliged.
May I please, Lordship? Lordship, I beg to mention for listing on criminal petition, Lordship, on Monday, Lordship.
Not Monday, Tuesday, Wednesday.
Wednesday. Much obliged, Lordship.
Lordship, I beg to mention for listing of a WBC on Monday.
WPC.
Yes, Lord. It was supposed to be, Lordship,
No.
fixed today, Lordship. But not
Mentioned
listed.
before the appropriate bench, WPC. Yes.
Please, Your Lordship, I beg to mention DA number 920/24. Kindly meta may be list on tomorrow.
Tomorrow is a working day.
Then Monday.
Please do not just walk casually to the court and make a mention. Please be mindful of where you are making a submission. Next.
Monday.
Next.
Please, your Lordship, I beg to mention an IA criminal for listing, Lordship.
For listing.
Any day next week.
Wednesday?
Obliged, Lordship. My Lord, I beg to mention for listing criminal revision petition. Criminal
IA.
revision petition. Criminal revision petition.
Criminal revision petition. Friday. Next. Friday.
May I please, Your Lordship, I beg to mention item number 29 of court number 14, Lordship.
20.
29. Kindly agenda meta for the day.
Well, case diary not received, my Lord.
Not received. As prayed for by MS D. Datta, learned counsel for the petitioner, lists this matter
Before review vacation, Lordship.
after 1 week on a date to be fixed by the registry. Next.
To mention item number 58 of court number 14, my Lord.
58.
The Conducting Counsel KB Pathak, who has been appointed as an amicus curiae, is out of station, my Lord. The leave note is already
58. Have you informed the counsel for the petitioner?
No, my Lord. I have
Please inform and make a mention. Don't make mention for the sake of mentioning. You must know the protocols for mentioning. You don't mention matters and take advocates for by surprise. You must make take their consent and make a mention.
The leave note that is already reflected in the cause list.
I cannot hear you.
My Lord, we have already submitted the leave note that is reflected in the cause list.
Ki kaise da pujana hai?
My
Yes.
Lord, we have already submitted the leave note. That
Yeah. You see, there's no point of you leaning towards me because there is a glass separation between here. So kindly speak in front of the microphone.
Am I audible, my Lord?
Yes.
Yes, my Lord. We have already submitted the leave note that is already reflected in the
Leave
cause list.
note is of no consequence. You haven't taken consent from
Yes,
the.
madam. I will
Please
take
take consent and we will see when the matter is called.
Yes, madam.
Yes, next.
I'm obliged.
May I please, Your Lordship? I get to mention criminal appeal 346.
For listing.
Yes.
When?
On 3rd April. Obliged.
Wait, Lordship. I beg to mention item number 37 of court number 14, Lordship.
Yes.
In this case day was called for, Lordship.
Not received.
My lord, case diary not received today.
37.
37, Lordship.
As prayed for by Mr. P. Datta, learned counsel for the petitioner, list this matter after 1 week on a date to be fixed by the registry.
My lord, I beg your pardon, my lord. My lord, in this case, my lord, such is submitted, lordship.
This is AB.
AB, my lord.
So wait for your turn. 37 cancel. Yes, call the list.
Item number 20. Item number 24, withdrawal from court number 27.
You are appearing in item 20.
Yes, my lord. I am appearing on behalf of Mr. S.M. Abdullah.
You want to withdraw?
Yes, my lord.
Petitioner has been arrested in the meantime.
No, my lord. This is anticipatory bail application.
Heard Mr. S.H. Sikdar.
No, my lord. I am J. Ali on behalf of Mr.
Heard
S.M.
Mr. J. Ali, learned counsel for the appellant, appearing on behalf of Mr. S.M. Abdullah P, learned counsel for the applicant. Stop. Also heard Mr. R.J. Bora, learned Borwa, learned additional APP for the state respondent. Stop. Mr. So-and-so, learned counsel for the applicant, submits that he has received instructions from his client not to press the instant anticipatory bail application. Stop. In view of the aforesaid endorsement made by the learned counsel for the applicant, the anticipatory bail application stands disposed of on withdrawal.
My lord, liberty may be given to file.
Next.
Item number 21 from court number 27.
My please, Lord. Well, in this case, my lord, the petitioner was arrested, my lord, on 14/1/2024.
You have the case diary, Mr. Borwa?
Yes, my lord. We have received
My lord, earlier your lordship released the co-accused lordship on 68 days. Today, in my case, my lord, 84 days in behind the bar. Lordship.
84.
Lordship, kindly see page 21, your lordship's order. Lord, on the length of detention, lordship, it was first.
Mr. Borwa, are they similarly situated?
Lord, the same affair, my lord.
FIR is, my lord, same, my lord.
Same.
My lord.
Allegation same.
Allegation same, my lord. Only, my lord, in this case, my lord, recovery is not made from.
Not nothing recovered from the lord.
Mr. Borwa, there is some difficulty in hearing the counsels today.
My lord.
Yes.
Am I audible now?
Yes.
But 84 days is in custody, lordship, and my lord, he has been arrested, my lord, and found some, my lord, fake gold
Yes.
in the shape of a boat, lordship.
So
These are all fake gold.
same thing, isn't it?
Same case, my lord.
All right. Considering length of detention,
My lord.
heard Mr.
M.H.
M. Rahman,
M.H. Ahmed.
Mr.
M.H. Ahmed. Lord.
M.H. Ahmed, learned counsel for the petitioners. How many petitioners?
Only one.
Petitioners. Stop. Also heard Mr. R.J. Borwa, learned additional public prosecutor Assam. Stop. This is an application under 439 CRPC for release on regular bail of the accused petitioner I. Mansoor Ali, who was arrested on
4/1/2024.
4/1/2024
24.
in connection with Bokhisto PS case number 4 of 2024, registered under section 120B, 420, 511, 489 capital A, 489C IPC. Stop. The same order at page 21. Same order. Only thing, the name of the learned APP changes. Alright? Chief Judicial Magistrate Kamrup?
Lost. Kamrup Metro.
Alright. Disposed of.
All like that.
Page 21. Huh?
Item number 1 from court number 14.
Only the 439 page of lordship.
So,
Lordship.
Rupak,
CD may be called for lordship.
call for CD
Before BU lordship.
and who is respondent number 2? Informant?
Lordship.
How is it related to the victim?
He's the informal, he's the father of the victim. Lordship.
Father of the victim. Notice,
has to go, Lordship.
notice to respondent number 2 through the office of the jurisdictional police station.
Lordship, my lord.
Stop.
And as well as my lord, register post, my lord.
And in terms of the mandate of this court in Deepak Nayak versus State of Assam, criminal appeal number, you took it from the court master and put it there. After 2 weeks,
Lordship, before you have to kindly Lordship. Before you
next.
Item number 2.
$376 to CD. Yes. List on.
Next week, lordship, because he has not appeared petition. Next week,
I'm calling for CD.
my lord. Then, my lord, 4th of April, lordship.
4/4/2024. Next.
Item number 3.
May I please Lordship, my lord, this matter related to item number 42 today's list, my lord, case that was called for in that matter.
All right.
My lord, case that the matter will be taken up along with 42. my lord.
40, 40,
42.
42 lagat
I
na.
know, Lordship.
Item number 5.
4 asil na hai? Defer.
Yes, Your Lordship. This is 439 application, Lordship. Allegation is under section 20B2.
NDPS.
Yes, Lordship.
All right. Notice. CD when, Mr. Borwa?
My lord, this is from Bongaigaon, lordship. That will be after vacation, lordship.
Call for CD. List on
19, lordship.
19.
Lordship, can
Four.
it be on before vacation, Lordship?
No, we can try on 10, lordship.
10.
10.
List on 10/4/2024.
I'm getting Lordship.
Item number 6.
IT Act.
For the timing, Lordship. For that.
No time being. CD. List on.
My lord, 18, lordship.
18/4/2024.
Item number 7.
POXO. Have you read the informant or the victim? Who is R2?
Victim of the father of the victim.
Father of the victim.
Let the notice be so, lordship.
Call for CD. Notice to respondent number 2 through the jurisdictional police station in terms for the.
This is Sarsitak matter, lordship. So LCR has to be called for.
Cancel it. Let the LCR from the court of. From the from the court of special court Nagaon,
Special
the
Judge Poxo.
special judge Poxo
Nagaon.
Nagaon be called through the registry. Stop. Let notice be issued to respondent number 2 through the jurisdictional PS with the police station for doing the needful in terms of the decision of this court in Deepak Nayak versus State of Assam. Reported in criminal appeal number so and so.
Date may be.
Yes. Date.
To 22/4, lordship.
List on 22/4.
Awesome.
Item number 8.
Lordship, section 4, my lord.
Same.
Lordship, only player is Lordship, he is a young boy of 25 years.
Here it will be LCR or case diary.
Case diary, Lord.
Case diary. Case diary and list on
My lord, 10th of April, lordship.
10th April.
And we will be allowed to take steps by justice in the police station, Lord.
You do whatever you want to do, but at the end of the day, it is the report of the police station which is required in terms of Deepak Nayak. So that is why I am saying notice through the jurisdictional police station. The same thing. Huh?
Item number 10. Sorry, item number 9.
9 also POXO.
POXO 10, my lord.
Who is the
Father, my lord.
the father is there? Okay. CD.
My lord.
CD. Notice through police station and list on
Before vacation.
Then 9th of April, lordship.
9/4/2024.
Item number 10.
Yes.
Actually, in this case, though, it's in the motion phase, but I'd like to point out one thing, minor. There is a glaring procedural failure.
Yes.
Without giving section 41A notice, minor, I have been taken into custody, my lord, on some certain hearsay evidence which is reflected from the forwarding report itself why I have been arrested. That's why I am placing it at the motion stage itself. If I
Monday, Mr. Bora?
Monday also.
Monday I will be out of station, madam. Let it be on Tuesday, on the
All right.
2nd, madam. We'll take
Call for CD Tuesday,
2nd of April.
2nd.
2/4/2024.
Let's not be on the 1st April.
No problem.
Item number 11.
439 execution, my lord. Petitioner,
420. Yes, Mr. Bora?
My lord, this is Merapane Road, sir.
When?
Item number 1.
Call for CD. List on Tamulpur. This is Tamulpur.
My lord, Kamrup College, my lord. My lord, he has mentioned, my lord, all.
item 6. Item 6.
Councils, please give me a date.
No, but he is confusing.
Item 11 and 6.
Okay.
Is there some confusion?
Yes, my lord.
No, my lord, because two matters are listed today, my lord. One is item number 6. My lord, with regard to item 6, my lord, since I could not appear, your lordship fixed a date on 18, my lord. Out of same PS case, my lord, there are two cases in this case, my lord. Already yesterday, my lord, the category has been fixed on 10th of April, my lord, this month, my lord.
Item number 6
6, my lord.
on 10.
10th, my lord.
In item number 6, you give the date 10. 10/4. And
here-
11 is also same FIR.
Not same, my lord. Petitioner is same, but FIRs are different, my lord.
Yes, 11 date
My lord, 11 Lord, say, it is from.
Tamulpur.
No, 11 is Merapane Road, sir.
All right.
11 is Tamulpur, my lord.
Next matter. You resolve your problems. Next matter.
No, my lord,
After some time.
On 10th, my lord. On 10th also, this matter also may be fixed on 10th.
10. CDL 10.
All right.
Yes, Mr. Das.
Please, your lordship. This is a revision petition, my lord. Challenging an order.
Where is it, the order? Page
Order, my lord, is at
12.
number 32.
Page number 32.
32, my lord. Well, what happened was that, my lord, the petitioner, my lord, is the informant of the Sorbuk PS case, my lord. His brother, my lord, was brutally murdered. His brother, aged about 18 to 19, was brutally murdered. And his body was found lying in a...
What is this order that you are seeking for quashing?
Yes, my lord, the thing, what happened was that, my lord, the learned public prosecutor, Borpata, my lord, while the case was fixed for argument, while perusing the record, he found that, my lord, there was an extrajudicial confession and statement, which was not annexed with the charge sheet. So he filed this petition under 311 for bringing the confession statement on record and also examining the witnesses, the magistrate. And the witness of the confession statement is, my lord, at page number 28. This is the original confession statement, my lord.
So this was denied.
Yes, on flimsy grounds, my lord. So, my lord, my humble submission is that at this stage, my lord, and regarding the prejudice, my lord, definitely, my lord, defense will get the opportunity to cross-examine the witness, my lord. So, the question of prejudice will not come. However, my lord, if this statement is brought on record, definitely the court will have a clear understanding as to what actually unfolded, my lord. I am the brother of the victim.
All right, notice.
Yes, my lord, Lordship, may kindly peruse, my lord, page 30 to last paragraph, Lordship.
I've seen. I'm of the firm view. That one.
That to last paragraph,
That the examination of the witnesses named in the petition so and so will be no help to the prosecution and it will be abuse of time. I have seen it. Anyway, you take instructions. I'm only issuing notice. I'm not staying.
Notice, Lordship, my lord.
The next date is fixed on 30th for argument, my lord.
Before that.
30th of this month.
No, it is not possible. 30th of this month,
So, my lord, stay
No.
the next day.
We are not staying anything. This is an application under section 397 and 401 read with section 482 of CRPC challenging the order dated 26/2/2024 passed by the learned session judge Borpeta in session case number 19 of 2021 rejecting the petition number 341 of 2024 dated 9/2/24 filed by the learned public prosecutor under section 311 of CRPC for summoning material witnesses. Stop. List. Issue notice, returnable 1 week.
My lord, he has not met the accused party, my lord, in this case. Lord. So they are also, my lord, necessary party. My lord.
Then, my lord, if your lordship will give me a liberty, we'll file amended cost title, my lord.
Issue notice, returnable 1 week. In the meantime, liberty is granted to the petitioner to submit amended cost title arraying the accused as an arrayed respondent. Stop. List after 1 week on a date to be fixed by the registry.
Item number 13.
Yes.
My Lord, I have come against the order passed by the MFC. My Lord, against
Where is the order?
page 80, my Lord, 80.
Yes, Mr. Sharma.
My Lord, by this order, my Lord, a maintenance of rupees 3,000 has been directed to be given to the petitioner, my Lord. My humble submission before your Lordship, my Lord, this is not a case of, my Lord, domestic violence. The wife of the petitioner who left voluntarily after, my Lord, 7 years before.
Mr. Sharma, it is only 3,000, so let notice go at this stage and we'll give you a short date.
My Lord, because, my Lord, the next date takes is 2nd of April in the trial court, my Lord.
Heard Mr. D.K. Sharma, learned advocate, learned counsel for the petitioner. Stop. This is an application under section 482 CRPC for quashing. The order dated 16/12/23. Mr. Sharma.
5/8/23, my Lord.
5/8/23 passed by the Court of Judicial Magistrate First Class Number 2 Kamrup at Amingaon in DV case number 86/2022, whereby payment of monthly maintenance of 3,000 was directed to the respondent aggrieved party. Stop. Issue notice returnable 1 week. You want to take dusty service as well?
My Lord.
Steps by registered post AD as and also through dusty. Stop. List after 1 week on a date to be fixed by the registry.
Item number 14.
My Lord, till my Lord order, till my Lord then, my Lord.
It's an order of August and you have come now. You could have come earlier. Yes, next. Yes, Mr. Roy.
My Lord, the petitioner, my Lord, is 83-year-old, my Lord.
You are seeking quashing of criminal proceedings.
Yes, my Lord, and because the two courts, but Supreme Court also, my Lord, interfered with it, and even the Calcutta Civil Court also interfered with it. Now the BIO...
No, Mr. Roy, I didn't get it. Supreme Court?
Supreme Court interfered, my Lord.
Interfered?
Yes, yes. Your Lordship may see the page 22, my Lord. Because he was a director from 10/3/2009 to 24/11/2008 to 11/3/2000, only 3 months, 15 days, my Lord. Last line, my Lord, page 32-22, we find that the appellant had tendered his resignation on 9th March 2009, which will be duly accepted by the said company. The courts below erred in not accepting the position. Accordingly, we set aside the impugned order so as to appellant is concerned. Then again, my Lord.
What is the impugned order?
Impugned order, that is the proceedings under the Companies Act, my Lord.
So that's a different proceeding. It is not a criminal proceeding.
Same thing, my Lord. When now next order also you will have to see.
No, but that is relating to the criminal to the company proceedings
Yes,
under the company
under the Security
Act.
Exchange,
Yes.
shares and preference shares and debentures. Then Lordship may see the Calcutta High Court he filed a page.
Mr. Roy, first you kindly show me this complaint proceeding is based on a complaint.
Complaint.
Kindly see the let us see the complaint.
Page 56.
Yes.
I have the honor that to report that BIO so-and-so I was initiated against Suraksha Agrotech Industries Limited under Suraksha cover group of companies bearing number so-and-so is registered with ROC West Bengal, having registered office at Nabalapalli, Kolkata, and opening of the branch office at Morigaon, Hojai, Silapata, Demaji, etc. During inquiry, it is found that Suraksha group of companies have their sister concern, namely Suraksha Agrotech Industries Limited, Suraksha India Industries Limited, and Suraksha Multi-State Credit Cooperative Society Limited, and the directors of the said company launches several deposit schemes running deposit secured non-convertible redeemable debentures fixed deposit schemes, etc. Widely offered high.
So, Roy, the allegations are serious. There are clear allegations of
Yes,
entrustment and misappropriation.
But Lordship will see that I was the director there, my lord, for 3.5 months only. And thereafter, I resigned from the company.
No, let notice go.
Lordship, just for a minute.
Notice go and Lordship will call for the case that.
Yes, because we do not know thereafter what has happened. There can be some allegations that may have come up, materials.
See the order of the, which starts from page 33, my lord.
Yes.
That is SEBI versus Suraksha Industries Limited.
Page 33.
33. It starts from 33.
This is before the Calcutta High Court.
Yes. Special court, my lord. Then here also, my lord, Lordship, turn to page 37, my lord. In view of the order passed by the Honorable Supreme Court,
Page
37, my lord. I'm not reading everything, my lord. In 37.
37.
In view of the order passed by the Honorable Supreme Court, I am of opinion that at the material time the accused was no longer director of the company, and therefore the accused has no liabilities in respect of.
No, in that case it appears that he was not a director at that relevant time. But in your case, you are saying you were a director for some time.
For 3.5 months.
So you see, that is the difference.
No, Lordship, just read it, my lord, just for.
Yes.
No liabilities in respect to activities and operations of the said company, and the accused is not at all connected or related with the allegations raised by the SEBI in adjudication order as well as in the complaint, and therefore I have no hesitation to hold that accused number 3, Barun Kumar Nandi, should be discharged from this case. No offence has been made out against him during the period 2009 to 2012, and accordingly the application filed by the accused person is disposed of. Then Lordship may see the last part, page 42. That is letter date after that last paragraph, Lordship. The application filed by the accused number 3.
One second. Yes.
Page 42, my lord. The last paragraph. The application filed by accused number 3, namely Barun Kumar Nandi, is hereby allowed. Accused number 3, namely Barun Kumar Nandi, is discharged from this case.
This is for discharge.
Discharge. So we filed an application for discharge here. Now.
And he was accused number 3 has been discharged.
No,
because accused number 3 was not a director at that time, correct?
He was same time, my lord. He was there for director of that company for 3.5 months. That is 24/11/2008.
No. What about Barun Kumar Nandi?
Barun Kumar Nandi, he is the Barun Kumar Nandi, my lord.
And the petitioner here is different.
No, Barun Kumar Nandi.
Barun Kumar Nandi. How come? But he is already discharged, and this is another case.
That is another case. On the same facts, my lord.
Mr. Roy, just one thing. You kindly come back to page 37.
37.
You see, there is a clear finding of the Calcutta High Court and also the Supreme Court that at the material time, the accused was no longer director of the company, and therefore the accused has no liabilities in respect of activities and operations of the said company, and the accused is not at all connected or related with allegations raised by SEBI in the adjudication order as well as in the complaint. And therefore, I have no hesitation to hold that the accused number 3 should be discharged from this case.
Yes.
Are you similarly placed in this case? Because you have said that you were a director for some time.
No, Lordship.
Now, where do we get it that you were?
Lordship may come to that order, my lord. Page 33 starts, my lord. May I read, my lord, this order?
Yes.
The learned Securities Appellate Tribunal in Mumbai heard the appeal and dismissed the same on the observation that the accused annexed letter dated 12/5/2010 exhibited, which is written by the appellant to the managing director of the company, wherein the appellant has clearly stated that he intends to discontinue as a director of the company with effect from 15/5/2010. This letter completely falsified the case sought to be made out in the appeal, and accordingly the appellant tribunal did not found any merit in the appeal and dismissed the appeal. On being dissatisfied.
All right. Where is the complaint?
Then comes Lordship, second page 34. The first para. The Supreme Court further observed that we find that the appellants are tendered his rendition on 10/3/2009.
All right. Where is the complaint?
Complaint, Lordship may see at page 56.
56.
My lord. Although police is now not searching, in fact they issued a notice, thereafter not the searching.
It says since 2010.
Yes.
The allegation is?
Yes, I am there till 10/3/2009. I tendered my resignation.
You were there till 5/2010, I think.
The Form 32 has been signed on this thing.
On when?
I am there till 10/3/2009, my lord.
10/3/2009.
2009.
9.
That is for Form 32.
No, my lord, that's what I beg to point out one thing, my lord. My lord, this is the case registered in the year 2015, Lordship. So now, Lordship, there are 9 years has passed.
We will only give an status quo till the next date. You see, prima facie, it appears that the allegations are after 2010. And the petitioner has already resigned on 10 March 2009. And taking that in mind, there are orders of the Supreme Court as well as of Calcutta High Court where he has been discharged. We are not doing anything today, but we are merely staying the proceeding till the next date.
That is why I am submitting. Let me take instruction. What is the matter?
You take your instructions, no difficulty.
Because in
yes.
the case of 2015, Lordship, if it
All
is
right.
searched, Lordship, if it is searched, then there is no use of stay, Lordship.
All right.
Let me take instruction, Lordship. Let the better come up on Monday, my lord.
All right.
We'll just take instruction. What is the
Heard Mr. J. Roy, Learned Senior Counsel, assisted by Mr.
Jayant Roy.
Jayant Roy, Learned Counsel for the petitioners. Stop. Also heard Mr. R.J. Borwa, Learned Additional APP for the state respondent. Stop. There is a private respondent?
No. My inspector is there, my lord. Number 2.
All right. This is an application under section 482 of CRPC 1973 for quashing of the criminal proceedings arising out of BI within bracket EOPS case number 22 of 2015 dated 28/8/2015 registered under section 120B 420/406 of IPC read with section 456 of price chits and money circulation schemes within bracket Banning Act 1978 and read with section 5 of Assam Protection of Interest of Depositors Act 2013 and any order and orders stop.
So far the petitioner is concerned.
So far the petitioner is concerned. Stop. The case of the prosecution is that this is an FIR case, that an FIR was lodged on 28/8/2015 alleging inter alia that BI within bracket EOP number 126 of 2011 was initiated against Suraksha Agrotech Industries Limited bearing having registered office at West Bengal and opening branch offices at Morigaon, Hosai, Silapathar, Dhemaji, etc. in Assam. Stop. It is the further case of the prosecution that during inquiry it was found that the said company have 3 sister companies, namely Suraksha Agrotech Industries Limited, Suraksha India Industries Limited and Suraksha Multi-State Credit Cooperative Society Limited. And the directors of the said companies launched several deposit schemes, i.e. recurring deposit secured non-convertible redeemable debenture, fixed deposit schemes, etc. and widely offered high rate of interest among the public and allured the public to their money in the above noted schemes since 2010. Stop. It is thus alleged that the directors of the company collected huge amount from public and filed away or fled away?
I think fled away.
And fled away by closing their office / branches without realizing maturity payment to the investors. Stop. What is the name of the petitioner?
This is Barun Kumar Nandi.
case has been registered against the directors, MD of the company, including the petitioner, I. Barun Kumar Nandi. Stop. Mr. J. Roy, learned senior counsel, appearing for the petitioner, submits that the petitioner had resigned from the company by filing C form. What is that form called?
Form
C?
32. Form 32.
By filing the relevant form, i.e. Form 32 before the register, before the
Register of Company.
Before the Register of Company on 10/3/2009. Stop. Accordingly, he submits that the petitioner was not there in the company. Was not there in the company for the period the offence is alleged, and hence no criminal case whatsoever can be said to be made out against the petitioner. Stop. In support of stop. Mr. R.G. Bora, learned APP, on the other hand, strongly opposes the prayer for interim relief and submits that. Stop. I have heard the. Before you say I have heard, you say issue notice returnable 2 weeks. Mr. Bora, learned APP, accepts notice on behalf of R1, registered post AD, in respect of R2 within a period of 2 days from today. I have heard the parties at the bar for, with regard to the interim relief. Stop. It appears that. Where is the Supreme Court order?
Page my lord, 22.
Page 22. It appears that the apex court in Civil Appeal number within bracket S 17979 of 2017 in the appeal which was preferred before the apex court against the order dated 1/8/2017 passed by the Learned Securities Appellate Tribunal Mumbai, has held that, within quotes you write, since the appellant was held to be the director of the said company at the relevant point of time, no, don't say that, held, within quote, we find that the appellant had tendered his resignation on 10/3/2009, which was duly accepted by the said company. Stop. The courts below erred in not accepting disposition. According, and then close quotes. Okay. In view of the aforesaid finding of the apex court, it is absolutely clear that the appellant had already tendered his resignation on 10/3/2009, and the same was accepted by the said company. Therefore, prima facie it appears that the petitioner was not in the company during the period in connection with which the offence has been alleged. Stop. As such, this court finds that there are sufficient. As such, the petitioner has prima facie made out a case for interim relief. Stop. Accordingly, further proceedings of BI EOPS case number 22 of 2015, dated 28/8/2015, registered under section 120B 420 406 of the IPC, read with so and so, you find it at page 14, shall remain stay until further orders.
So far the petition.
No, my lord, only till next day.
Shall remain stay until the next day, so far as the petitioner is concerned. Stop. List again on.
My lord, let it be on come immediately after vacation on 19/4.
List on 19/4/2024.
Item number 15.
May I plead, Your Lordship? Lordship, petitioner has filed an Jimma petition before the learned court below. It was rejected.
Jimma.
Jimma. Status report may be called for, my lord. Status report so far as the PS case 300 of Jagir PS case number 300 of 2023 may be called
351.
Jagir PS case number 300 of 2023.
Where is that?
Impugn order is page number 20. The last paragraph. The operative.
Where is the number? Okay. Let the case records of Jagirot PS case number 300 of 2023 be called for through the registry. Stop. Any private party? No.
No.
List on?
Before due vacation, my lord.
List.
After vacation, no.
Date?
18.
List on 18/4/2024. Next.
Oblate.
In this case, earlier 2 occasions, report was called for.
Yes.
Third day.
Mr. Borwa?
My lord, matter will be taken up at 2 p.m. also.
Next.
70.
May I please, Lord? 438 bail application, my lord. FIR is page, my lord.
CD?
My lord.
My lord, this is from Jagirot PS, Lordship.
CD?
My lord, petitioner is not named accused, my lord. Already named accused already released on bail, my lord. Similar order is there, my lord. My lord, only I came before the Lordship court praying for bail, my lord. I am the friend of the one of the.
Which is the FIR? Page 14?
FIR is page 14, my lord. I am Saddam Hussain, my lord. I am not. I am the friend of the Salam Ali. Only on suspicion.
700 fake Aadhaar cards.
My lord, my lord. And due to on suspicion, my lord. So many of the cards and documents are seized by the Superintendent of Police, my lord, of Jagirot, my lord. Somiran Bushra, my lord, of Morigam, my lord. That is why, my lord, on apprehension, my lord.
Main accused is Salam Ali and Partha Protein Borderline. And you are?
Salam Ali. I am Saddam Hussain. I am not in the FIR, my lord. My name is not in the FIR, my lord.
Is there any call for? It said the record is going on.
Yes, but Salam Ali has already got interim bail from this court. He is named. Here the petitioner is not named. Let him appear then.
Call for the CD.
Heard Mr. B. Islam, learned counsel for the petitioners. One petitioner.
One
petitioner. Stop. Also heard Mr.
DP Goswami.
DP
Goswami.
DP Goswami APP. DP Goswami learned APP for the state respondent. Stop. This is an application under section 438 of CRPC 1973 seeking grant of anticipatory bail to the petitioner, i.e. Saddam Hussain, who is apprehending arrest in connection with Jagirot Police Station case number 9 of 2024, registered under section 120B, 420, 468, 471 of IPC. Stop. Call for CD fixing on 19/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner in connection named above in connection with the aforementioned case, he shall be released on interim pre-arrest bail on furnishing bail bond of rupees 50,000 each with 50,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, appear before the investigating officer within 7 days, and the other 2 conditions. List accordingly.
Item number 18.
It is 17. Yes, 18.
Yes, Lordship.
FIR.
No, Lordship. There is no FIR, Lordship, against me, Lordship. The para 3, Lordship. On 16 to 2024, Lordship, the SI of the Pokrajar, Lordship, searching me and visited my house, Lordship. Thereafter, Lordship, on 21/2, Lordship, again visit me, Lordship, and asked
For what? In connection of what?
No, Lordship, I don't know, Lordship.
So I have to take instruction whether any FIR case is registered or not, Lordship.
List on?
List on, Lordship. Monday, Lordship.
Tuesday, Lordship. Tuesday.
So I will say call for CD. For what? There will be no CD. There is no case.
Lordship. So whether any FIR or case is registered against him, Lordship, we have to take it.
Let the instructions be obtained in connection with the allegation made in paragraph 3 of the anticipatory bail application. Stop. List on? 29/3/2024. Next.
Complex.
29P.
Lordship.
20.
On 1/4/2024. Next did you?
Item number 90.
Assam Cattle.
My lord, I am the owner of the vehicle, my lord. I am no
You are the owner of the vehicle.
My lord, my lord.
How many what was carried?
10 number of cattle, my lord.
10 numbers.
My lord, I am no way connected with the case, my lord. But at this point, my lord.
Okay, you appear.
I will appear, my lord.
Heard Mr.
A.W. Aman.
A.W. Aman, learned counsel for the petitioner. Stop. Also heard Mr. D.P. Goswami, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC seeking for grant of bail to the accused petitioner I. Motiar Rahman, who is apprehending arrest in connection with Gosaigaon PS case number 45 of 2024, registered under sections 379, 411, 34 IPC, read with section 13(1)(14) of the Assam Cattle Preservation Act. Stop. Call for CD fixing on 22/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner I. Motiar Rahman, he shall be released on interim pre-arrest bail on furnishing bail bond of rupees 15,000 to the satisfaction of the arresting authority, subject following conditions. Appearance within 10 days. List accordingly.
DP of land.
Item number 20.
FIR page.
Page 15, Lordship.
$50,000 cash. Let him appear. Your name?
MZ Shah.
Sorry?
MZ Shah.
MZ Shah. Heard Mr. MZ Shah, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned APP for the state respondent. Stop. This is an application under section 438 CRPC for granting pre-arrest bail to the accused petitioner i.e. Mamtaz Ali Kakati, who is apprehending arrest in connection with Gitanagar PS case number 69 of 2024, registered under section 380 IPC. Stop. Call for CD fixing on 22/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner named above, he shall be released on interim pre-arrest bail in connection with the aforementioned case, subject to the following conditions. Appear before the arresting authority within 7 days. Investigating officer. Next.
Wait, Mr. Lordship. Lordship, the FIR is at page number 12.
1 second. Rupa. Change korai dibo. FIR is at page
12. Basically, a civil case, Your Lordship.
Yes.
Page 12, Lordship has got it.
Yes.
The below scheduled property was the joint property of my father Said Ali and Fatima Bibi on 24/11/1919. The said Fatima Bibi sold her property, which is half of the property, that is so and so, to Makabbir Ali.
There are allegations of tampering government records.
Yes, Lordship, that is the allegation. What happened, in fact, Your Lordship, these petitioners, Your Lordship, they have filed an application for mutation at page number 23.
Call for CD. List on.
No, Lordship, go.
Wait for some time.
19-4.
19 before Bihu?
Lordship, then 10-4.
10/4/2024.
Petitioner 1 and 2, Your Lordship, they are both are senior citizens.
Yes, next. Given a short date.
Item number 22.
May please, Your Lordship. 438 bail application, Lordship will find FIR at page 60.
Page?
60, my Lord.
60.
My Lord.
Yes.
My Lord, may I read, my Lord?
Yes, please.
With due respect, we to state that the below mentioned scheduled land has been purchased by the number so and so dated 25/2/93. But Onima Sarkar.
Land grabbing.
My Lord, that my Lord, the allegations is that the Onima Sarkar had, my Lord, sold some part of the land.
Who are you, Mr. Sharma?
Yes, my Lord. I have purchased, my Lord, the.
You are the purchaser.
Yes, and in the name of my Lord, registered partnership firm, my Lord.
He is the purchaser. Let him appear.
My Lord.
Heard Mr. R. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. D.P. Goswami, learned AP. Oh, sorry.
P. Sharma.
P. Sharma. Also heard Mr. P. Sharma, learned APP for the state respondent. S.H. Sharma.
SAR.
S-A-R-M-A. Huh? This is an application under section 438 of CRPC seeking grant of pre-arrest bail to the petitioners, i.e. Shri Anjan Das and Pradeep Kolita, who are apprehending arrest in connection with Bhangagar Police Station case number 26 of 2024 registered under section 120B 420 406 468 of IPC within bracket GR case number 1392 of 2024. Both are the purchasers, Mr. Sharma?
My Lord, in the name of my Lord, registered firm, my Lord.
The facts of the case of the prosecution is that one Anima Sarkar has fraudulently prepared a power of attorney on 19/11/2019 by showing another woman in the place of the informant and has sold the said land to other persons. Stop. It appears that the petitioners are the purchaser of the aforesaid land. Stop. Call for CD fixing on
22-4.
22/4/2024. Stop. It is provided, considering the facts and circumstances of the ground, it is provided that interim PR is the same thing. Huh? Appearance within 10 days.
Problem.
List accordingly.
Problem.
Item number 23.
May I please, Lordship? My Lord, this item is. May I please, Lordship? My Lord, this item also, my Lord, is connected to the item number 42, my Lord.
1 second. Masha, just. This is connected to 23.
Item number 22, my Lord.
22.
42, my Lord.
40. Oh, 42. All right. Then you wait.
My Lord.
Kindly take up.
Yes. Next.
Item number 63 of supplementary list.
May I please, Your Lordship? My Lord, FIR, Your Lordship, is fine, my Lord, page 12, my Lord. My Lord, gist of the FIR is there, my Lord. Some unknown person, my Lord.
Page FIR?
Page 12, my Lord.
Yes.
Some unknown person, my Lord, stolen a e-rickshaw, battery and charger, my Lord, from the godown of the informant.
Theft incident.
From the godown of the informant, my Lord.
E-rickshaw, battery, charges.
My Lord. In connection with this case, my Lord, one person has been arrested, my Lord. Page 14, my Lord, the forwarding report, my Lord. What happened, my Lord? This person, arrested person is, my Lord, is from the petitioner's place, my Lord, from Zagirot, my Lord. But he knows the petitioner, my Lord. He sent messages, my Lord, to the petitioner, my Lord, with intent to sell the batteries, my Lord. The petitioner refused, my Lord. It is in the apparent in the forwarding report, my Lord, page 14, my Lord. Kindly see, my Lord. Ground of arrest, my Lord. 1, my Lord.
Where is your name?
My name is not there in the FIR, my Lord.
Is not.
My Lord. Kindly see the forwarding report, page 14, my Lord. The person who was arrested, my Lord.
Yes, page 14.
Yes, ground of arrest, my Lord. Second,
Yes.
third para, my Lord.
Yes.
First ground, my Lord. During investigation, image of the stolen articles of the mentioned case was seen in the mobile of below mentioned accused person, and he shared the said image to the different persons for selling the stolen
Yes, Mr.
articles.
Sharma.
Yes,
My lord.
to sell to me, my lord. But I refused, my lord, because he
It is the petitioner does not appear to be named in the
Yes,
FIR
yes,
forwarding.
yes.
Subsequently, something may have come.
Something may have come.
Of course, maybe from the statement
Case-
of the
case diary,
co-accused.
my lord.
So, case there, and in the meantime, let him appear then.
nobody named, my lord. 2 persons arrested, my lord. Nobody named, my lord, in the forwarding.
Right, Mr. Sharma?
My lord.
Heard Mr. S.M. Molla, learned counsel for the petitioner. Stop. Also heard Mr. P.S. Sharma, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC 1973 for grant of pre-arrest bail to the petitioner in connection with Gorsuk police station case number 80 of 2024. The petitioner question I Parma Deka. It appears the case of the prosecution is that a theft incident had occurred at the Messrs. Ronak Enterprise Gudam on 13/3/2024, and in connection with the said theft, one Muzahid Diwan was arrested. Stop. Call for CD fixing on
22
4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner named above, he shall be released on interim pre-arrest bail in connection with the above noted case. Bail bond of 15,000, 30,000, 30,000. Satisfaction of arresting authority, subject, of course, to the following conditions. Number 1, appearance before the investigating officer within 10 days. And number 2, inducement. Number 3, similar offences. List accordingly.
Item number 24.
You will understand the conditions.
May I please observe?
20.
The matter is quashing of the proceeding on the ground that both the parties.
Quashing of FIR.
FIR as well as the proceeding matter.
Yes. On the ground.
That both the parties have made amicable settlement.
Offence was under.
Offence is under 323, my lord, 448, 294, 427 and 506.
It's a joint petition.
Joint petition. Preferred by mother and son.
Mother and
Son. Mother also.
FIR is for domestic violence. At page 10.
Page 10.
Who has filed the affidavit?
Both of them have filed the affidavit. Separate.
Farida Begum is the mother.
Mother.
Where is the compromise?
The compromise means we have filed it jointly. No separate agreement has been made.
Where are the paragraphs?
Madam, may kindly see paragraph 7, paragraph 9 and paragraph 10.
These offences are compoundable. Mr. Sharma, all compoundable offence? heard Mr. I. Chaudhary, learned counsel for the petitioner. Stop. Also heard Mr. P. Sharma, learned APP for the state respondent. Stop. This is an application under section 482 of CRPC 1973 for quashing of FIR, i.e. Bhorolomukh Police Station case number 757 of 2020, registered under section 448, 294, 427, 323, 506 of IPC. The FIR is dated. FIR dated. Yes, Mr. Chaudhary.
FIR dated 11/12/2020.
11/12/2020. The case of the petitioner is that the petitioner number 1 and 2 are son and mother respectively, and due to some misunderstanding between them, the petitioner number 2, i.e. mother, lodged an FIR against the petitioner number 1, and now both of them have amicably settled their differences and have approached this court for quashing the said FIR by the present petition. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the informant stroke mother, along with her son, has jointly filed the instant petition for quashing the FIR on the ground that the matter has been amicably settled between them. Stop. It further appears that the accompanying affidavit has been sworn in by the informant mother herself. Stop. Yes, compoundable?
294
is not compoundable. Considering the averments made in paragraph 7 that the matter has been amicably settled between the petitioner number 1 and 2 and are living happily, this court is of the considered view that for ends of justice, the FIR is required, that further proceedings in connection with the said FIR dated 13/12/20. 13/12/2020. 11/12/2020 be quashed, stopped, ordered accordingly, disposed of.
Actually, the charge sheet was also submitted. There is the PRC proceeding is here. Page number 23.
Page number
23.
Ordered accordingly, don't say that. As such, the further proceedings in connection with FIR FIR so and so and the proceeding of PRC case number so and so pending in so and so be quashed and set aside. You will get the details at page. Why is this not paginated? Mr. Chaudhary, your petition is not paginated. Prayer, paragraph 13. How did the registry allow this petition? Anyways, disposed of. Paragraph 13. Yes. Registry लिखवाई दी petition को numbering है card है. Yes.
May I please, Your Lordship? I am for the respondent number 2, my lord.
Yes, petitioner not there. None appears for the petitioner when matter is called. List after 2 weeks.
Short date may be given, my lord, because this
Give me a
matter is
date.
not maintainable.
Give me a date. List again on.
Bill.
22/4/2024. Next.
Item number 26.
Yes.
But I am playing Zimma of the better nurse, my lord. 825 numbers of better nurse, my
A
lord.
report was called. Yes, Mr. Sharma, you have the report.
My lord, yes, my lord. Kindly to my lord last para.
My lord, I would like to place a judgment, my lord, for the similar coordinate.
Jima of what?
Zimma of the better nurse.
Betel nut.
Better nurse.
Track is already given to the respective owner. So the only thing it is foreign, but otherwise it is fit for human consumption.
My lord, but it is foreign.
It says where the expert opined that the sample conforms to the prescribed standards as per food safety. So on that ground, you take proper conditions and it can be returned. What is the use of keeping it? There is one decision of a coordinate bench in connection with betel nut, Justice A.D. Chaudhary's. You have that?
Justice Ravi.
No, there is one of Justice A.D. Chaudhary. You have that. We'll take it up after some time. Connected to betel nut also. This point was clearly dealt there. Right. Try and have that. We'll call it after some time. It all up piece of material.
Item number 27.
May it please your lordship. My lord, 439 application.
Mr. Roy Chaudhary, just 1 minute. Next, Mati divide here.
May it please your lordship.
Yes.
My lord, 439 arrested on 3/1/2024.
This is bail application.
Bail application, my lord.
CD there, Mr. Goro?
Charge sheet file.
Charge sheet file.
Charge sheet file. Your lordship may look into last order dated 15/3/24.
15/3/24.
3/24.
Yes.
And my lord, this is the report of that copy sent to the respondent number 2 and it was dispatched.
Who is R2?
R2 is the informant.
This is a POXO matter.
POXO matter. My lord, I am not named in the FIR. Because the persons who are in the
Just a second, Mr. Roy Chaudhary.
FIR at page 8, I am not named.
But for that custodial detention, what is the stage of investigation?
One difficulty is there, my lord, FSL report we have not received, my lord. If it turns, my lord, that it is a, my lord, genuine, my lord, rhino horn, that it would be, my lord, case should be defined, my lord.
50 days.
But 60
My lord,
days is the mandatory.
that is there, my lord. Kindly have a
60
my
days
lord, kindly have my lord short date maybe.
Monday.
My lord.
Monday.
Next, my lord, Tuesday, my lord. I will
Tuesday.
certainly.
But 60 days is the mandatory. my lord.
Tuesday. You want the FSL report, Mr. Sharma? Mr. P. Sharma, learned APP for the state respondent submits that though case diary has been made available, however, the FSL report is not available in the same. Stop. Accordingly, he seeks him some time. Stop. Let this matter be listed on Tuesday, i.e. date to deliver. Next. 2/4/24.
Item number 30.
May I please, Your Lordship?
Case diary?
Case diary received, Lordship.
Yes, FIR?
Page number 17, Lordship.
Page number?
17, 117. Allegation is that he was carrying illegal timber. Lordship.
Carrying illegal timber.
When police apprehended, Lordship, he could not produce any document, Lordship. That is why he has been detained along with the timber. And the
How many days?
36 days, Lordship.
39 days to this.
39 days.
9 days. Yes,
39.
When was he last interrogated?
my lord, he was interrogated, my lord, on 21/2, Lordship.
21/2, date of arrest.
Date of arrest. That day only he was interrogated, Lordship.
Do you need
Thereafter,
for further
Lordship,
detention? Because it appears that investigation is on.
Material investigation going on. Only, my lord, the report of the DPO of Tinsukia is pending, Lordship. Because
You see, for that, the liberty of a person is also concerned vis-a-vis article.
that part I leave it to Lordship.
It's already 39 days. This is item number?
30.
Investigation.
Your
pending
Mr.
on this.
8 Alukdar.
Mr. A. Talukdar.
Lordship.
Heard Mr. A. Talukdar, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Borwa, learned APP for the state respondent. Stop. This is an application under section 439 CRPC for bail for the petitioner I. Ajmat Ali, who was arrested on 21/2/2024 in connection with Bokhisto PS case number 109/2024, registered under sections 120B 379-411 of IPC, read with section 2441 of the Assam Forest Regulation Amendment Act 2018. Stop. The facts of the case is that on 21/2/2024, an FIR was lodged alleging inter alia that on 22/2024, on receipt of a secret information from reliable sources that a truck bearing registration number AS23AC0978 was carrying illegal timber from 10th mile, a GD entry was made Vide Bokhisto PS GDE number 559 dated 22/2024, and the informant along with other PS staff proceeded therein and thereafter checked the said truck and found the timber was being carried without any supportive documents. Stop. Accordingly, a case was registered. Correct? Stop. Mr. A. Talukdar, learned counsel for the petitioner, submits that the petitioner is totally innocent and has no role to play. Stop. He further submits that the petitioner is ready and willing to cooperate with the investigation of the case. Stop. Mr. R.J. Borwa, learned APP, on the other hand, strongly opposes the prayer for bail. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation has substantially progressed. It further appears that the petitioner has been languishing in jail since last 39 days. It further appears that he was last interrogated on 21/2/2024, i.e. the date of arrest. Stop. Thereafter, he has not been interrogated further. Stop. Considering the length of detention, this court is of the considering the length of detention, this court is of the considered view that further detention of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, it is provided that the petitioner named above shall be released shall be released in connection with the above noted case, furnishing bail bond of rupees 30,000. Satisfaction of learned.
CJM Kamrup.
CJM Kamrup. Conditions 1, 2, 3 disposed of.
But only he's on detention today is the 37 days, not 39.
37 days.
I'm sorry.
And also say one thing where I've said that Monjat Koso further appears that it further appears that there is no adverse material as regards the antecedent of the petitioner so far collected by the investigating officer. There is nothing adverse as regards antecedents.
That may not be mentioned.
But it is not there in the case diary. I am only stating that if it is there, it should have been there. Yes.
Item number 31.
31 case diary received.
31?
Case diary
received.
May I please, Lord?
Yes.
Lord, FIR at page 12, Lordship. Petitioner is not FIR name accused person, Lordship.
Page?
12, Lordship.
Yes. Demand of money.
Demand of money by making the...
Yes, Mr. Borwa.
28 days, Lordship. She is a lady.
One witness she has implicated also one lady she has demanded money also. What happened also they are my lord so-called reporter also. They entered into unisex parlor also. And there is my lord allegation is that there is something my lord some unauthorized thing was.
Yes, I've read. That is there in the FIR.
Allegation. And my lord regarding money also, one witness said also one lady has demanded money but name has not been mentioned.
That lady's name is not mentioned.
Not mentioned also. But she has been
who is before this court for bail?
She is one of the Lordship.
He.
She.
Her statement recorded, Lordship. She is one of news reporter of my lord some live news portal, my lord.
When was she interrogated?
She was interrogated, Lordship, on the date of her arrest, Lordship.
That is
29/2, Lordship.
29/2.
An investigation is going on, Lordship.
Investigation is going on. Custodial detention perhaps is not required. You are Mr.
M.K. Hussain, Lordship.
Heard Mr. M.K. Hussain, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Borwa, learned APP for the state respondent. Stop. This is an application under section 439 of CRPC for granting regular bail to the petitioner, i.e. Rumi Nayak, who was arrested on 29/2/2024 in connection with Chanmari PS case number 48 of 2024, registered under section 120B, 143, 384, 354A, 354C, 506 IPC. Stop. The case of the prosecution is that on 27/2/2024, an FIR was lodged alleging inter alia that on 21/2/2024, a group of 15 to 16 persons with cameras entered into the informant's business place, i.e. hair parlor, i.e. a parlor situated at Rajgor, and captured videos bringing allegations of illegal activities and abused and thereafter demanded rupees 3 lakhs by threatening with the captured video. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that the allegations are totally false and the petitioner has been wrongly implicated for the offence alleged. Stop. Mr. R.J. Bora, learned APP, on the other hand, strongly opposes the prayer. He further submits that he submits that the investigation is going on and the statements of the witnesses have been recorded. Stop. He further submits that one of the witnesses have implicated that one lady has demanded money. However, the identity of the lady is not revealed as of now. Correct? Stop.
No, on the basis of his statement, this petitioner was arrested.
Stop. He further submits that on the basis of the aforesaid statement of the witness, the petitioner and the other accused persons have been arrested. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation has substantially progressed. Stop. It further appears that the statements of the victims have already been recorded. It further appears that the petitioner has also been interrogated on the date of arrest, i.e. 29/2/2024. It further appears that based on the statement of the witness to the effect that one lady whose identity is not known, the petitioner has been suspected for the offence alleged. Stop. Considering, it further appears that the petitioner has been languishing in jail since last 28 days. Stop. Considering the above facts and circumstances, this court is of the considered view that further detention of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, it is provided bail bond of 30,000, satisfaction of CGM,
Kamrup M.
CGM Kamrup M. The three conditions and disposed of.
Item number 32.
Procedural, 439 application, Lordship. As of today, 45 days behind the bars.
45?
Yes, Lordship. FR is on page 14, Lordship.
Page?
FR is on page 12, Lordship.
Yes.
Lordship, allegation is of credit card fraud, Lordship.
CD there, Mr. Borwa.
We have received the case diary, Lordship, and my lord, so far the investigation carried out by the IO, Lordship, sufficient materials has been collected against this person, Lordship.
How many days? 45.
45 days.
44 days, Lordship.
Forwarding report is on page 14, Lordship.
Do you need him for further investigation? His detention is necessary?
Investigation is still pending, Lordship, so that submission may be recorded, Lordship. Because, Lordship, he is the executive of bank credit card of ICICI and SBI, Lordship. He is authorized, Lordship, but that is by taking this advantage of his authorized executive of the bank, Lordship. He contacted the customer, Lordship, they obtained the secret
that
number.
Is right, you see, but bail is not punitive, correct? That is why my question to you is, do you need him for further investigation? Further detention is required because you said that materials have already been collected.
Collected against him, Lordship.
Isn't it?
Investigation is pending, that may be mentioned, Lordship.
All right. You are Mr.
P.K. Das, Lordship.
Heard Mr. P.K. Das, Learned Counsel for the petitioner. Stop. Also heard Mr. R.J. Borwa, Learned APP for the state respondent. Stop. This is an application under section 439 CRPC seeking granting bail to the accused petitioner I. Nurul Amin Talukdar, who has been arrested on 14/2/2023 in connection with Cyber PS Panbajar case number 4 of 2024, registered under section 419/420 of IPC, read with section 66D of IT Act 2000. Stop. You were not named in the FIR?
No, not named.
The case of the petitioner is that the case of the prosecution is that an FIR was lodged by one Monmi Deka stating inter alia that on 6/2/2024 an unknown person through a phone number called the complainant by introducing himself as a bank employee. Stop. It is further alleged that the said person said that he needed her credit card to set new credit limit. And after the accused person, and after that, the accused person came to the house of the informant and took the credit card number of the complainant, including the CVV number of the complainant. Stop. It is further alleged that thereafter informant received an OTP on her mobile and the same was shared with the accused person. Stop. It is further alleged that after sharing of the said OTP, a sum of rupees 40,786 was debited from her account. Stop. Accordingly, a case was registered. Mr. M.K. Hussain.
Mr. P.K. Das.
Sorry, Mr.
P.K. Das.
Mr. P.K. Das, Learned Counsel for the petitioner, submits that the petitioner used to work in credit card department of ICICI and SBI Bank, and in connection with his job, he used to make phone calls regarding payment reminders to customers. Stop. He further submits that the petitioner is not currently working in credit card department of the said bank. Stop. He further submits that he has been falsely implicated for the offence alleged. Stop. Next para. Mr. R.J. Bora, APP for the state respondent, opposes the prayer of bail. Stop. He submits that the petitioner is. You said he is working where? He has a.
He is the executive of.
Petitioner is the executive of.
Bank credit card. Offices of ICICI.
And SBI. SBI Bank. Stop. He further submits that accordingly he has taken the advantage of his official position and duped the customers. Stop.
And obtained a CVV number for the purpose of.
I have heard the submissions made at the bar and I have perused the materials available on record. Mr. Borwa, I am again asking you, what is the stage of investigation?
The investigation that is pending because the money that has been withdrawn fraudulently, that has not been recovered.
Anybody else involved? Do you need them? What is the report?
That is investigation is going on because he is the main accused on the basis of the phone number. Because he was earlier contacted them as a customer, then he comes to her residence. So on the basis of her phone number, he was arrested.
Any adverse material against his antecedents? Any apprehension of the IO that he will flee from justice? You see, if these materials are not given merely because an offence is there, this court cannot curtail the liberty. There has to be some materials.
That may be mentioned also that the investigation is sufficiently progressed.
It appears that the investigation has substantially progressed. Stop. It further appears that the statements of the witnesses has been already recorded under section 161 CRPC by the investigating officer. It further appears that the petitioner has been interrogated on
my lord. On
14/2/2024, it further appears that the petitioner has been languishing in jail since last 45 days. Stop. It further appears that from the materials collected by the IO, there are sufficient materials implicating the accused as the main accused for the offence alleged. Stop. Undoubtedly, the offence is grave. Undoubtedly, the magnitude of the offence is grave. Stop. However, bail is not punitive. Stop. The object of the bail is to secure the appearance of the petitioner by a reasonable amount. Stop. Considering the length of detention and the totality of the facts and circumstances of the case, this court is of the considered view that further detention of the petitioner may not be justified for the ongoing investigation. Stop. As such, bail is granted 30,000 and satisfaction of CGM Kamrup Metro. Following conditions disposed of.
Obliged. Item number 33.
May it please your lordship.
PCA Khondivasan. Yes.
The petitioner was arrested in a trap case with a tainted money of 15,000 rupees. Thereafter, he was charged with an offence punishable under Section 7A of Prevention of Corruption Act.
Where is the FIR?
The FIR is at page number. The translated copy of the FIR is at page number 14.
Yes.
Your lordship, I would like to make 4 important submissions.
FIR first.
Page number 14, your lordship.
Yes, please read.
With reference to the subject cited above, I have the honor to inform you that I have a plot of land measuring 1 bigha located at Ramnagar, Torapur, Part 4, near Kachar Driving School. The said plot of land was inherited from my forefather. In the last 2023, I started construction of workshop in the said plot of land for opening a garage by taking loan from SBI Silchar Tarapur. But when the construction work was just about to complete, one Sri Abhijit Kar, field officer, surveyor of Silchar Development Authority.
17,000. And then bribe amounting to
15,000.
15,000 on his possession.
Total 15,000.
Total 15,000.
Recovered from him.
Recovered.
Recovered from him. Just trapped.
And what is the petitioner is holding the post of surveyor.
Surveyor. Your lordship, the GD entry.
How long?
23 days.
Offence is serious corruption. It's a menace to the society, and he has taken advantage of his position. What is the stage of the investigation?
Investigation sufficiently progressed. Trap operation was made, and he was caught red-handed along with 15,000 rupees.
He was caught red-handed along with 15,000. Further detention required?
Lordship, investigation is still in progress. Lordship.
It's in progress.
Lordship.
May I submit your lordship?
23 days.
24 days as on today, I think.
May I submit your lordship?
Yes.
Your lordship, the trap team was constituted on 4 March 2024. However, the complaint and the GD entry was made on the next date.
Those are procedural aspects. Anyway, let the investigation is going on and is at an active stage. At this stage, your name?
V. Jammar.
Heard Mr. V. Jammar, Learned Counsel for the petitioner. Stop. Also heard Mr. D.P. Goswami, Learned APP for the state respondent. Stop. This is an application under section 439 of CRPC seeking release of the petitioner, i.e. Sri Avijit Kaur, who was arrested on 5/3/2024 on bail in connection with ACP FIR number 18 of 2024 dated 5/3/24, registered under section 7A of Prevention of Corruption Act 1988 within bracket as amended in 2018 with Vigilance and Anti-Corruption Assam at Guwahati. Stop. The case of the prosecution is that on 5/3/2024 an FIR was lodged stating inter alia that while the informant was constructing a workshop in the subject land, the accused petitioner, who is a field officer stroke surveyor of Silchar Development Authority Silchar, visited the said construction site and asked the informant to produce NOC permission regarding the construction. Stop. It is further alleged that in connection with the aforesaid requirement of NOC permission, the accused petitioner demanded bribe from the petitioner. Stop. From the informant. Stop. Mr. V. Next para. Mr. V. Jamar, learned counsel for the petitioner, submits that the petitioner is totally innocent and has been falsely implicated in the offence alleged. Stop. Next para. Mr. D.P. Goswami, learned APP for the state respondent, strongly opposes the prayer for bail. He further submits that from the materials available on record, it appears that the accused petitioner has been caught red-handed with 15,000 rupees. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation is at an active stage. Stop. It further appears that the...
Your Lordship, may please submit one.
You mind letting this court finish the order first? It further appears that there are sufficient materials available in the case diary implicating that the petitioner, who is a surveyor of the Silchar Development Authority, Silchar, by taking advantage of his position, has prima facie committed an offence. Stop. Considering the magnitude of the offence, this court is not inclined to grant bail to the petitioner at this stage. Stop. It further that since the investigation is at an active stage, it is imperative that to untruth the truth. Stop. And it is and at this stage, if bail is granted, the same may hamper the ongoing investigation. Stop. Accordingly, with the aforesaid observation, this bail application stands rejected, disposed of. Yes, your submission, one submission you are making, you want that to be recorded?
Your Lordship, he has never been interrogated in jail since last 15 to 20 days.
All right.
He was only interrogated at the time of
in
police
the
custody.
submissions, you say that petitioner submission, he further submits that the petitioner has not been interrogated since the date of arrest.
He was interrogated during police custody only.
That he was only interrogated during police custody and
during jail he was never interrogated.
And during the custody in jail he was not interrogated.
At the same time, Your Lord.
Stop.
Item number 34.
Disposed of.
Lordship, we pass over the matter for the time being. Senior is on legs.
We have received the case diary.
All right.
Item number 64.
My Lord, NCR was called for in this case, my Lord. My Lord, as part of the last status report, the case was fixed for furnishing copies, Lordship. As per the last date was 22/1/2024. After that, there is no update, Lordship.
So far, my information is that one of the last two occasions, my Lord, although the case was fixed for evidence of the victim, my Lord, she never turned up, my Lord.
She has not appeared.
She has not appeared, my Lord. And my only prayer...
Where from?
It's from Rongia, my Lord, Rongia.
Can you have the up-to-date materials on Tuesday?
My Lord, no, it has to be called for through registry, Lordship.
Or
it has to be called for through registry, Lordship.
Or I can produce the copies, my Lord.
Very well.
Then your Lordship may fix it next week, my Lord.
Tell me a date.
On 4th, 5th, my Lord.
Petitioner is given liberty to place the certified copy? Photocopies of the
orders
early
orders
of the order sheet in connection with
my Lord special POXO case number 53/2023.
Stop.
In the meantime, up-to-date status report may be called.
Stop. In the meantime, let up-to-date case up-to-date what? Mr. Borwa, we are giving a short date that will anyway not come. When the order sheet is going to be produced, the information will be available.
I leave it to Lordship, my Lord. If he can produce the up-to-date report.
All right. In the meantime, let the up-to-date LCR also be called for through the registry. Stop. List on
5th of April.
5/4/2024.
I am applied.
I shall just come back in 5 minutes.
Time being item number 26.
Yes, this is that GIMA petition.
Yes, Maharaj, I have connected these two orders passed by the
Markov.
Markov and Govinda Gop.
Where is the refusal order?
Page 30, ma'am.
Page
30.
30.
Yes, ma'am.
It was rejected because these reports were called for.
Yes, my lord. Whatever grounds are similar or not, my lord.
You see, the idea is to release it. The idea is not to keep it for long. That is the object, right? Now, you already have the reports. Why do you need it? Do you need it for anything? You can keep the sample. You don't need the entire stock. So this court can follow these two judgments and direct release with certain conditions.
My lord.
So we will do similar in Govinda Gop. We will set aside the order and we will say that let the magistrate court consider the application afresh in terms of the determination in Ram Shankar Moria and Sundar Bayambalal, because there the entire object and how to release everything is given.
Yes.
Because now that you have the reports, yes.
That can be done.
My lord, another order I can refer to.
That's all right. We are not going to go any further in this matter.
And my report, my lord, may be kept in record.
That we shall. In item 26. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Stop. Also heard Mr. P. Sharma, learned
B, my lord.
B. Mr. B. Sharma, learned APB for the state respondent. Stop. By way of this petition, filed under section 401 read with 482 CRPC, the petitioner has sought setting aside and quashing of the impugned order dated 6/2/24 passed by the learned additional CJM Karimganj in Badarpur PS case number 347/2023, rejecting the Jimma prayer of the betel nuts to the petitioner. Stop. Mr. B. Sharma, learned APP, submits the report dated 26/3/2024 received from the investigating officer, indicating that the FSL report and the FSL, and which is the other report? Two reports have come, no?
Yes, my lord. One from my lord.
FSL, not FSL, the expert examination report and the FSL report has been received. Stop. It further appears that on perusal of the aforesaid FSL report, it is found that Exhibit A containing betel nuts, the expert has opined that the sample conforms to prescribed standards as per food safety regulations with respect to the test carried out. Stop. It further appears from the perusal of the agricultural report, which is Exhibit B, that the betel nuts are not local in nature. Stop. Next part. The Honorable Apex Court, while dealing with disposal of seized materials, irrespective of whether it is an application under Section 451 or an application under Section 457 of CRPC, has laid down the following propositions of law. In bracket, you write Sundarbhai Ambalal Desai. So, citation 2022, volume 10, SSC 283. 1, 2, 3, 4. This you will get in this page. In the present case, the JIMA application of the petitioner was rejected by the magistrate court, by the additional CJM, by the court of the additional CJM Karimganj by order dated 6/2/2024, primarily on the ground that the reports of the expert and FSL were not available. Stop. Since the aforesaid reports are already are now available, this court is of the considered view that this matter can be disposed of with the direction for a fresh consideration of the JIMA application of the petitioner. Stop. Accordingly, in view of the consensus, in view of the aforesaid, the impugned order dated 6/2/2024 in connection with so and so is set aside and quashed, and the matter is remanded to the court of additional CJM Karimganj to consider the application afresh in terms of the determination made in Sundarbhai Ambalal Desai within brackets Supra and in accordance with law. Stop. Accordingly, this criminal revision petition stands disposed of.
Item number 65 through BC.
Disposed of, huh? This is now
LCR was called for in this case.
65. LCR has come. Have you gone through, Mr. Bora?
Yes, my lord.
Who is appearing for the petitioner? There was a request for VC.
My lord, yes.
Yes, Mr. Mori.
My lord, may I read before lordship? My lord, it is charge-sheeted matter, my lord.
Charge-sheeted, Mr. Bora?
Yes, my lord.
Yes, charge-sheeted.
Then investigation is completed.
Investigation completed, charge is submitted, then charge is also framed, lordship.
But further detention required.
Yes, my lord, it's a commercial quantity of the NDPS, my lord.
Is NDPS?
Yes, NDPS matter, my lord.
Where is the FIR?
FIR page 20, my lord.
Page?
It starts. Page 20, my lord. It starts.
Yes. Yes?
My lord, as per the allegation, my lord, it was in course of Nakajiking, my lord. The total number of 363.70.
Your voice is not very
grams
audible.
of suspected.
It's not very clear. The video and voice is not very clear.
And my lord, here there are two accused persons, my lord. Charge sheet will find, my lord, page
Accused is the name.
33, 34, my lord.
One is Sabir Ahmed, that is the petitioner.
One is?
Sabir Ahmed, Lordship.
Where do I find his name?
So Sabir Ahmed, my lord, he is the petitioner of the bail application, my lord.
Acha. No, his name is not there in the FIR.
It will be there, my lord, because from his position...
Sabir Ahmed, yes. He is the suspected driver.
Driver, Lordship, and from his position, Lordship, the heroin was recovered and it is commercial quantity, Lordship.
They were carried through by a vehicle which was apprehended, and then these contraband articles have been seized.
Yes, my lord.
And he is the driver.
He is the driver.
Yes. Then what happened?
On my lord, 12/9/2023, charges framed against both the accused persons.
On 12?
12/9/2023, my lord.
Yes.
Thereafter, it was fixed.
Charges
framed, my lord, under section 21C.
Where do I get that?
My lord, that is, my lord, from the scan copy, Lord.
12/9/23 charges framed.
Charges framed, my lord.
Under section
21C.
Yes.
/29 of the NDPS Act, Lord.
NDPS.
After that, Lord, the case was fixed for evidence, Lord. But Lord, probably the no witnesses turned up on that day. That is why, Lord, up to date status report was called for, my lord.
That is available.
But that I have to go through up to date status report. Yes, my lord. Status report received, Lordship, as it was called for, my lord. But Lordship may kindly peruse, my lord, that till now, Lordship, the summon has been issued to the witnesses, but they have not turned up.
So trial has started.
Trial has started, Lordship.
Yes, Mr. Counsel, there are reasons to believe that the petitioner has committed the offence. Possession, contraband articles have been seized from his possession. What do you have to say? Section 37.
My lord, only my limited submission, my lord. I have been arrested on 10/1/2023. Today, my lord, 10/1/2023. Today, my lord, I am already 43 days behind the bar. 443, my lord. I'm sorry, my lord. 443. And my lord, charge sheet was filed on 30/4/2023. And
yes,
11 months, my lord. After filing the charge sheet, 11 months continue, my lord. Till no prosecution witness could be examined. As it appears from the charge sheet, there are 6 prosecution witnesses, my lord. Although learned court below, my lord, on 15 occasion, my lord, it will be on record, my lord, LCR. 15 occasion, my lord, PW has been called for after framing charge, but PW seems to not turn up, my lord. So, my lord, only my limited prayer is delay in trial, my lord. Charge part may be considered, my lord. And
23 is the date when charge sheet was submitted or charges were framed?
No, charge sheet submitted, Lord.
Charge was submitted, my lord.
On, my lord, in the year 2023 itself, Lord. Charges framed on 12/9, Lord.
That is 12/9 is the charges framed by the trial court, correct? And when was charge sheet submitted?
Yes.
Charges submitted, Lord. That will be, my lord.
Page Batch number 29, my lord. It starts. Annexure C.
Yes, sir. It's submitted on 34, Lord.
34.
34, 2023.
There you go.
Some suggestion, my lord.
All right. We've taken note of your
My lord.
submissions.
My lord, some suggestion I rely, my lord, in that regard, my lord. Lordship, whether it is there on record or not, I mail it, my lord, because of some inconvenience, my lord.
No, it has not come. Anyway.
For suggestion, my lord, where Honorable Supreme Court and High Court, my lord, Lordship is aware that when there is a delay in trial, my lord, Section 36 embargo, Section 37 embargo under the Section 37 will not be fatal, my lord, in case of delay of trial. And, my lord, citation is, my lord, criminal appeal, my lord.
Mr. Counsel,
Criminal appeal.
You see, firstly, the mails have not come to the court master, number one. Secondly, there are no local counsels also here to hand over anything. So you do one thing, you mail it again, and this matter will be listed on Monday. List on Monday.
My lord.
Let the citations relied by the petitioner be mailed to the court master of the concerned court.
I'm grateful, my lord. Grateful, my lord. Applies, my lord.
Item number 35.
Next one.
35, we have not received the case diary today.
35. Await case diary. List on. Interim, if any, shall continue till then.
My lord.
List on.
Let it be after vacation, Lord. On 22 April.
22/4/2024. Next.
Item number 36.
36.
Item number 36.
None appears for the petitioner when matter is called. List on.
My lord, we have received the case diary.
List on.
That will be next week, Lord. On, my lord, 9th of April.
9/4/2024.
Item number 37.
Charge sheet.
Charge sheet submitted, Lord.
Can you appear?
Yes, sir.
Heard Mr. P. Datta, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Borwa, learned APP for the state respondent. Stop. This is an application under section 438 of the CRPC seeking grant of anticipatory bail to the petitioner I. Rahamtullah.
Yes, sir.
Rahamtullah Ali, who is apprehending arrest in connection with Halwating PS case number 1 of 2024 registered under section 379 of IPC. Stop. It is Mr. R.J. Bora, learned APP for the state submits that the charge sheet has been filed by CS number
02/2024
2024
dated 5/3/2024
dated
5/3/2024 under
Stop.
section 379 IPC.
Under section 379 IPC of IPC. Stop. So we disposed of. Interim order was dated 15/2/2024. Appear before
CGM Shivsagar.
CGM Sipsagar?
Yes, sir.
Court of CGM Sipsagar. Within
15 days.
15 days? Within 15 days. Disposed of.
Item number 38.
38, we have not received the case diary today.
Await case diary. List on.
After vacation.
After list on 19/4/2024. Till then, interim order passed earlier shall continue.
Item number 39.
FIR please, Lord.
39.
My lord, case diary receipt.
My lord, FIR is page 11, my lord.
FIR page
11, my lord.
Yes. $10,40,000.
My lord. My lord, already the petitioner has refunded the sum of the amount, my lord.
Hmm?
Already the present petitioner, my lord, though his name is not in the FIR, my lord, but he has made an agreement with the informant, my lord. I have annexed the page number, my lord, 25, my lord. Page 25. Annexed 6, my lord.
Yes. Yes.
My lord, here, my lord, the...
For refunding
Yes, my lord.
the money
My
in
lord.
6 installments.
My lord.
Yes.
That is not a part of the case diary, my lord. He may furnish it to report IO, my lord. Because, my lord, as per my lord, bank statement, my lord, he have received the money and withdrawn, my lord.
This is for anticipatory bail.
My lord, it is anticipatory bail.
Then let us grant him interim bail. Let him appear before the IO.
My lord.
And then we'll see what is to be done.
My lord.
We are not disposing of this
My lord.
anticipatory
Yes,
application.
But, my lord, in the case diary, my lord, there is sufficient material.
That is why I am not making it absolute today, since it appears that the petitioner is not named in the FIR and that the petitioner has already entered with a compromise. Let him submit all that. This is an application under section 438 of CRPC 1973 for grant of pre-arrest bail to the petitioner I. Abdul Hamid, who is apprehending arrest in connection with Karimganj PS case number 41 of 2024, registered under sections 420, 406, 468, 471 of IPC. Stop. Considering that the petitioner has entered into an agreement with the informant for repayment of the
Whole amount, my lord.
repayment of the alleged misappropriated amount, comma, this court is of the view, this court is of the considered view that pending disposal of the anticipatory bail application, the petitioner be granted the privilege of interim pre-arrest bail. Stop. Accordingly, it is provided interim, appear within 10 days. Arresting authority. Bail bond of rupees
25,000.
30,000.
And my lord, on the next date, I will produce the updated case diary. My
And
lord,
let the up-to-date case diary be produced on the next date.
Along
List
with
on?
List on, my lord, 24th of April, my lord.
2024. 2024.
My lord.
16. Yes, item 16.
Item number 16.
We were trying to show obtain instruction, Lordship.
Yes.
Whether any case is pending or not against this. There is no case pending, Lordship. There is no case pending against this person, Lordship.
No case pending.
My Lord.
Now, Lordship, kindly see page 13 of my petition.
No, but if there is no case pending, in which case shall this
There is
court
no
grant?
apprehension, Lord.
There is no apprehension, and in connection with which case would this court
Case
grant you
13, Lordship,
anticipatory
kindly
bail?
see. Yes, that is fine.
The
Lord,
report
that
is there.
fine. Yes.
In item 16, heard Mr. M.U. Mandal, Learned Counsel for the petitioner. Stop. Also heard Mr. R.J. Borwal, Learned APP for the state respondent. Stop. This is a application under section 438 of the CRPC for granting bail to the petitioner Rafiqul Islam. Where have you stated about your apprehension?
Yes, my Lord. Lordship, kindly see, my Lord, page 13. We have annexed the, my Lord, complaint.
Page 13.
Page 13. This is the complaint lost to the...
This complaint is not registered.
No, it is not registered.
Apprehending that he shall be arrested in connection with an FIR dated 8/3/2024 lodged by one Rafiqul Islam. Stop.
This is my complaint to the SP.
Oh, this is your complaint?
Yes.
No, you are apprehending arrest in connection with what?
That has been explained at para 7, my Lord.
That is what I am asking.
Yes.
Please be attentive when a question is put to you, counsel. Paragraph 7.
Para 7 and 8.
Who is apprehending arrest as the IC Niagara Police Outpost has been searching him, for him. Stop. The case of the petitioner is that on 5/3/2024, on 4/3/2024, one sub-inspector from the Niagara Police Outpost entered into his dwelling house and tortured the family members of the petitioner Accordingly, the petitioner filed a complaint before the Superintendent of Police Dhubri against the said sub-inspector on 8/3/2024. Stop. However, no action has been taken on the said complaint. Stop. Apprehending that the petitioner shall be arrested in connection with a non-bailable offence, the present anticipatory bail application has been filed. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. In terms of the order dated 21/3/2024, a report has been called from the concerned police station as whether any case is pending, as whether against any criminal case is pending against the petitioner. Stop. Today, when the matter was called, it has been submitted. You have instructions, or
Madam, we have been informed verbally.
It is submitted by Mr. R.J. Borwal, Learned APP, that that information has been received, that there is no criminal case pending against the petitioner. Stop. In view of the aforesaid endorsement made by the Learned APP for the state respondent, this anticipatory bail application is devoid of any merit whatsoever. Stop. The apprehensions of the petitioner cannot be looked into while exercising power under section 438 CRPC. Stop. Accordingly, the anticipatory bail application stands dismissed. This more stuff.
Time being item number 30.
30? Yes, Mr. Kaur.
Render my apology for
No
not
problem,
being,
Mr. Kaur.
not being present on the first
Yes,
call.
CD is there?
Yes, we have received the case, Judge.
Yes.
Well, this is a case where Sumoto police have registered an FIR alleging offences violating the Assam Moneylenders Act, and section is 72C2, and the punishment is 3 months or with fine. It's a bailable offence. Now, so far the other sections are concerned: 406, 420, 422, 423, 386 is my lord IPC is by putting a person of extortion in fear of death or grievous harm. My
No
respectful
ingredients.
summary-
No ingredients there.
No, you can't.
Where is
be-
the FIR?
Yes, ma'am. Page 21. Just to prolong my detention in custody, I was arrested on 26/2/2024. And I'm
You are
behind the-
arrested on?
26th of February 2024, and today is I'm 32 days in custody. So my custodial detention.
When were you interrogated?
Yes, my lord. I've been
On the date of arrest?
Yes, I've been taken even into police custody for 3 days. Then I was sent to judicial custody on 29/2/2024. And after that, my lord, there is no interrogation, nothing. Just to it's being a punitive detention for me. And the main plain reading of the FIR will suggest that it is it's of lending money at a high rate without valid license.
Yes, Mr. Borwa.
Yes, my lord.
No ingredients of where is deception, where is entrustment, misappropriation.
My lord, in this case,
Those
my lord,
allegations are
in
not
this-
there.
My lord, in this case, my lord, witnesses were examined, lordship. My lord, what he has done, lordship, while giving the loan, lordship, he took, my lord, gold ornaments, then passbook, then ATM card, and whenever, my lord, the interest
So
was
that
not
is
paid,
an
lordship,
illegal.
yes, illegal, without license, lordship.
Yes.
And my lord, when the loan amount is not repaid,
This
lordship,
is for
he started
that
pretending.
that is section 7, right, Mr. Kaur?
Yes, 7C,
7C.
Money laundering act is bailable, lordship. Regarding the other section, lordship, he started threatening when the loan is not repaid, lordship.
Where is that allegation? That is there in CD?
Yes, there is statement of the witnesses, lordship.
All right, but 36, how many days?
32 days in custody, 3 days police custody.
Any adverse materials, antecedents,
But material is not there, lordship, but investigation.
similar
is there,
offences earlier, any?
No, lordship.
So only undoubtedly offences
Yes, that is
grave,
when
but
the loan
that
is-
sole
without
cannot be
any-
the criteria also. As
Without
I
any valid license and lordship,
Very
when the loan was not
bail
repaid.
is not punitive.
And several items has been seized from his possession, lordship.
That are all been seized. That means investigation is almost
Going on
substantially progressed,
This is
yes.
pending, lordship. Investigation is
all right. Heard Mr. B.D. Kaur, Leonard Senior Advocate, assisted by
P. Gupta. P. Gupta.
M.S.P. Gupta, Learned Counsels for the petitioner. Stop. Also heard Mr. R.J. Borwa, Learned APP for the state respondent. Stop. This is an application under section 439 CRPC 1979 for grant of regular bail to the petitioner, i.e. Shri Hemanta Kumar Das, who has been arrested on 26/2/2024 in connection with Ajara PS case number 40 of 2024 registered under sections 406, 420, 422, 423, 386 of IPC, read with section 7C2 of the Assam Money Lenders Amendment Act 1968. Stop. The case of the prosecution is that the accused petitioner is involved in the illegal act of money lending at higher interest rates without any valid permission of the concerned authorities. Stop. It is the further allegation of the prosecution that the accused petitioner keeps the ATM cards, bank passbooks, jewelries, land documents, blank signed papers, written agreements, etc. as mortgage surety from the borrower to ensure payment, and when the borrowers are unable to repay the said debts, it is alleged that the accused petitioner threatens the borrowers with dire consequences for which the borrowers are forced to pay the high interest rates. Stop. Mr. B.D. Koral and Athenia Council submits, next paragraph, submits that as per Section 7C2 of the Assam Money Lenders Amendment Act 1968, the imprisonment shall be maximum 3 months and fines which may extend to rupees 500 or both, and is bailable offence and is a bailable offence. Stop. He further submits that there are no ingredients as regards the other sections, i.e. 406, 420, 422, 423 and 386 of IPC. Stop. Mr. R.J. Borwal and APP, on the other hand, strongly opposes the prayer for bail. Stop. He submits that the investigation, he submits that there are materials collected by the investigating officer which indicates that the petitioner the investigating officer during investigation has seized several items including bank checks, various blank signed papers, various passbooks, calculation books, land documents, cash of rupees 7,900, money receipts and a golden color piece of metal, etc. He further submits that during interrogation, he further submits that the petitioner's statement under section 161.
Other witnesses implicated him.
No, has he also, because there is a...
Yes, he was also examined.
He submits that during interrogation, the accused petitioner admitted his guilt regarding involving money lending case. Is it correct?
Yes, he said, Lordship, that my lord, he used to give money, Lordship, to the people.
Regarding lending money. Stop. He further submits that statements of other witnesses have also been recorded under section 161 CRPC, which indicates that the petitioner is regularly lending money.
My lord.
Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop.
But he has denied, Lordship, that he took interest at the higher rate.
For convenience, Section 7C2 of Assam Money Lenders Amendment Act 1968 is quoted hereunder for ready reference. You will find it at page 5. Then you say. It appears that the investigation of the case has substantially progressed. It further appears that the statements of the witnesses have been recorded and the petitioner has also been interrogated. It further appears that the petitioner has been languishing in the jail since last 32 days. Stop. It further appears that there are no materials as regards deception and inducement available on record against the petitioner. Stop. Considering the... Don't say that. Considering the facts and circumstances of the case, this court is of the considered view that further detention of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, it is provided that, yes, satisfaction of
Chief Judicial Magistrate, Kamrup Metro at Guwahati.
Chief Judicial Magistrate, Kamrup Metro, Guwahati. Yes. 30,000.
Yes, ma'am.
And the 3 conditions, bail application stands disposed of.
Item number 40.
We are deeply on that.
So, Service notes
Notice issued to respondent number 2 also.
not yet returned.
Yes, madam.
But it's a POXO matter.
Yes.
To save time,
Should you receive, madam?
Were you on interim? No.
No, madam.
FIR?
Case 12.
Yes. Who are you?
Driver, madam.
Driver of the truck.
Of the truck, madam.
Suspected.
Has the truck been recovered?
Later on recovered, my lord, along with my lord, 50 packets, my lord.
50 packets of?
50 packets of, my lord, that pan masala, my lord. That was
allegedly it was 300 packets.
Yes, my lord. That my lord, that rest, my lord, 250 packets are not recovered yet, my lord.
This is AB?
AB, my lord. And he is the driver, and he is way to, my lord, from railway station to, my lord, go down at Betpisi, my lord. So he is the main culprit, he is the prime accused, my lord, in this case.
My lord, I will appear as and when required, my lord, for a statement of my lord, for my statement.
To tell my lord,
opportunity may be given, I will appear with the police.
The problem is the entire package is not recovered. Had it been recovered, this court could have thought about granting you anticipatory bail.
That the petitioner is not only the driver, but other persons are
Alright,
there.
sorry. You are Mr. T.K. Bhuya?
A. Ali.
Huh?
A. Ali.
A. Ali. Heard Mr. A. Ali, learned counsel for the petitioner, stop. Also heard Mr. P. Sharma, learned APP for the state respondents. B. Sharma, right? B or P?
B, my lord.
B. B. Sharma, learned APP for the state respondents. Stop. This is an application under section 438 CRPC for granting pre-arrest bail to the petitioner, I. Sharuf Khan, who is apprehending arrest in connection with Ajara PS case number 42 of 2024, registered under section 407 420 IPC. The case of the prosecution is that the accused petitioner has misappropriated the 300 packages which was being transported by him as a driver of the truck to deliver the same to the requisite location. Stop. Mr. Ali, learned counsel for the petitioner, submits that the petitioner is totally innocent and has no role to play in the offence alleged. Stop. Mr. B. Sharma, learned APP for the state respondent, on the other hand, strongly opposes the prayer for bail, anticipatory bail. Stop. He submits that out of the 300 boxes alleged to have been taken away by the petitioner while driving the truck in which the said boxes were being transported,
only 50.
Only 50 boxes have been recovered. Stop. He further submits that since the petitioner is absconding, further investigation is not being able to progress. Stop. Considering that the presence of the petitioner is utmost important for unearthing the truth, the application for anticipatory bail at this stage cannot be granted. Stop. Accordingly, the application stands disposed of. Rejected.
Obligers.
May I appeal?
Yes.
Here the
Case diary?
14.
Yes, Lord.
FIR is at 14, your lordship.
1-4.
1-4.
Yes.
So here, what happened, your lordship? The victim who has lost the FIR, she purchased a scooty and she took the loan from TVS credit, And now her allegation is against the employee of Sakir Ahmed, Rahul Amin.
You are not them?
I am not that. But she has listed some name later on that they are also involved in such kind of.
Yes, Mr. Goswami. Primarily, the accused is Sakir Ahmed and Rahul Amin, who has convinced her to make this payment of 65,000 for purchase of the TVS scooty.
Lordship.
Yes.
Ashish Hussain is the main accused.
Correct. So
Yes.
let him appear. This is AB because it appears that maybe anyway it is. This court should not make any comment at this stage. But 42.
42.
You are Mr. N.N. Upadhyay. Heard Mr. N.N. Upadhyay, learned counsel for the petitioner. Also heard Mr. D.C. Goswami, learned APP for the state respondent.
DP Goswami.
DP Goswami. Sorry, DP Goswami. I'm sorry, I actually on the last 2 weeks there were a different set of PPs, APPs. So that is why today I'm getting confused with all the names. This is an application under section 438 of CRPC for granting of anticipatory bail to the accused petitioner, i.e. Sanjay Chauhan, who is apprehending arrest in connection with Chanmari PS case number 42 of 2024, corresponding to GR number 914 of 2024, registered under section 120B 406 419 468 420 of IPC. Stop. The case of the prosecution is that an FIR was lodged on, the date is not here in the typed copy, FIR was lodged on
1912.
19/2/2024, alleging inter alia that two accused persons, namely Sakir Ahmed and Rahul Amin, had convinced the informant to make a payment of 65,000 rupees for purchase of a TVS scooty. Stop. It is the payment was made. Was the payment made? I don't think payment was made.
Some payment was made.
Payment was made to the Sakir Amin, the rule.
All right. It is further alleged that you are Mr.
Sanjay Chauhan.
It is further alleged that along with the aforesaid two accused persons, there are more accused involved. Stop. Out of which one of them is the petitioner. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that the petitioner has been roped in unnecessarily. Stop. He further submits that the petitioner has no role to play for the offence alleged. Stop. Mr. D.P. Goswami, learned APP for the state respondent, strongly opposes the prayer for bail. Stop. He further submits that investigation has substantially progressed and statements of witnesses have been recorded. They say what?
They said that they have main cases
from where it appears that the adverse materials collected at this stage are primarily against the two main accused.
Ashish Hussain.
Main accused is Ashish Hussain.
Against the main accused, who is Ashish
Hussain.
Who is one Ashish Hussain.
He has taken all the
Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that there are no adverse materials at this stage available against the petitioner. Stop. Considering the same, this court is of the considered view that custodial interrogation may not be justified for the ongoing investigation. Stop. As such, pre-arrest bail, bond of rupees
30,000 or whatever.
30,000, arresting authority appear within 15 days. 15 days? 15 days. And the other two conditions?
Item number 3 and
disposes of the bail, anticipated bail application. Yes, what are you saying?
Item number 3 and 23, Lordship. The same,
Are same.
FIR, Lordship.
Same. There are also no adverse against those two persons?
Item 3 is bail, Lordship, bail application. He is in custody, Lordship.
Item number 3, my lord, Rahul Amin.
3 is a bail.
Yes, my lord.
Before we go to 3, then let us deal 23. That is an anticipatory?
Yes, Lordship. Yes, my lord.
23.
That is my lord.
Exactly, Akedibo.
Sakir Hussain, my lord. Can
All
you say
right.
affair, my lord?
Sakir.
Ashish Hussain is the main person, my lord.
Yes, yes, I'm granting you. Do you want anything else?
My lord, my lord.
Why you waste the judicial time unnecessarily when you are getting the relief you want?
Sorry, my lord. Sorry.
Yes, and it was Sailoba Sakir. And
Rahul Amin is the
bail
application.
How long?
For my lord, 25 days.
It would bail holiday. 25 days. 25 days. Satisfaction of learned? CJM Kamrup. CJM Kamrup. And exactly the same. Alright, disposed of. Item number 3 and
23.
3 and 23. Mr. Chaudhary, you want to say something?
My lord, I pay your lordship indulgence, my lord. Item number 50, my lord, which was earlier listed before the other bench, my lord. That is a part.
Alright. Item number?
55.
55.
My lord, with due respect, the connected Appeal 51 item, my lord, my name is wrongly reflected. Actually, there was an earlier judicial order also, 51. Respondent SG Borua, my lord.
51 or 50?
No,
Mine is 50. She is repairing in a connected item number
51.
So 50 and 51, right?
Yes, my lord.
In item 50 and 51, list before appropriate bench, stop. And I think 50 is there or not today. Probably it was not there. They may have cut it. Anyway, if it is there, release before appropriate bench. And in 51, you say
Name of the respondent, my lord, SG Borua.
SG. G
Sumita
for
Kohai Borua.
the name of the learned counsel for respondent MS SG Gohai.
SG Borua.
SG Borua be reflected in the cause list. All right.
Okay.
How many for mentioning at these are with regard to item number 54, 55 and 56 of court number 14. Actually, I'm not feeling well. That is why I pray for an adjournment.
Item number?
54, 55, 56.
54, 55, 56.
Yes. I've taken it
As prayed for by MS
Deepak.
D. Borgumaya, Learned Counsel for the petitioner with consent from the other side.
Not petitioner, Lordship.
Petitioner, my lord. We are, my lord.
You are for respondent?
In fact, we have filed impleadment applications. We are yet to be impleaded as proper parties here. We have filed IAs. 3 IAs are there.
You are the applicant in the IA.
Applicants.
Learned Counsel for the applicant in the connected IA with consent from the other side.
My senior D. Sekia, assisted by NNSC, my lord.
List this matter again on?
Lordship, any date convenient after BU vacations?
Any date after BU.
After 2 weeks on a date to be fixed by the registry.
And humble prayer, my lord. Interim order may kindly be done.
Interim order passed earlier shall continue till then.
Obliged.
My lord, I beg to mention item number 62, my lord. For
Mentioning time is gone. This is not the time for mentioning. Wait for your turn. Yes.
My lord, I want to update the matter, my lord, at 3:30. I have taken the consent of the petitioner side.
Wait for your turn. Yes.
Item number 52.
What is this matter, Mr. Bogoi?
This is an appeal by the union against acquittal. I am an amicus representing the acquitted persons. Mr.
They are not there.
Yes, Mr. Kyal has to be there.
Anyway, this bench is only for today. None appears for the appellant when the matter is called, despite the matter being fixed at 2 p.m. Stop. List this matter next week on a date to be fixed by the registry.
My lord, a date should be fixed because the pending matter of 2000.
Yes, tell me.
Any date, Lord.
Next week? Tuesday?
Yes.
Tuesday date. Alright. But you say Mr. D. Gogoi, Learned Counsel for the amicus curiae, is present. Alright.
Item number 43.
Yes.
Yes, the Lordship, FIR was filed on 21/12/2023. Lordship, case 70. Lordship,
you are on interim?
No, Lordship. Lordship, I marked one thing. The informant's husband name is Jose Ali. Case 70, Lordship.
FIR is at page
70.
Yes, please.
Lordship, as because we have filed 3 FIR, Lordship, before that, this FIR has been filed by the informant, Lordship, whereas her husband's name is Jose Ali. With due respect and humble submission, it is stated that on 25/11/2023, at around 2 p.m. in the afternoon, the accused came to the house of the informant by taking advantage of the informant being alone at the house and addressing the informant as sister-in-law. The accused petitioner has clicked some objectionable photos from his mobile phone by putting his hand around the neck of the informant and further threatened the informant to kill her if she informs the said incident to her husband or other. On 20/12/2023, in absence of my husband, the accused person came to my home at about 7 p.m. at night and forcibly raped
Yes,
me.
Mr. Goswami.
The petitioner's brother.
Here the allegation is of attacking and robbing about and taking rupees 45,000 from his pocket. And at page 28,
the petitioner informant Lordship Sanbor Ali, the present petitioner Lordship, accused number 3 Jose Ali, and accused number 4 Tahiron Begum, informant Lordship.
who is Ainal Haq? At page 23, the informant.
Lordship, petitioner's brother.
Huh?
Petitioner's brother.
Petitioner's brother.
Page 28, petitioner has lodged the FIR.
Yes.
Lordship, thereafter another FIR was lodged.
How many FIR?
Now the petitioner's informant's husband has committed rape on the petitioner's brother's wife. Lordship.
Where is that? He has further submitted that it appears from the evidences, from the materials, from the statements recorded under 161 CRPC, there are materials to implicate the petitioner as regards the allegation of threatening. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the materials collected by the investigating officer recorded available in the case diary that the investigation has substantially progressed and the statements of the witnesses have also been recorded under 161 CRPC. Stop. It further appears that there are no adverse materials collected against the antecedent of the petitioner at this stage by the investigating officer. Stop. Considering the facts and circumstances of the case, this court is of the considered view that custodial interrogation of the petitioner may not be justified for the ongoing investigation of the case. Stop. Next para. Accordingly, it is provided pre-arrest bail, bail bond of rupees
10,000. 15,000.
15,000. Arresting authority appear within
10 days.
10 days. Disposed of.
Item number 45.
Yes, criminal appeal.
My lord, the appeal is already admitted, my lord, and this LCR call for receipt.
So we'll post it for hearing?
IA, my lord. No, my lord, bail may be granted, my lord.
In IA, we have to file a objection, my lord, but if it is ready, but my lord,
all right, you file your objection, we'll post it next week.
My lord.
Next week, the date may be fixed, my lord.
Your name?
A. Rashid.
Your name?
A. Rashid.
Huh? Naam to give?
A. Rashid.
Heard Mr. A. Rashid, learned counsel for the respondent number 2, submits that some time may be granted for filing objection in the connected interlocutory application. Stop. Prayer is not opposed. Stop. List this matter on
next Friday.
Date to dia?
5th of April.
5/4/2024.
No further time, my lord. Earlier
Next.
also time given.
Next.
Item number 46.
This is POXO.
Yes, Lordship. May I please, Your Lordship?
APP, your examination made to that effect?
Yes, no, nothing is there, madam. I am giving the evidence also, my lord. I have a Xerox also copy. And just.
He was PW?
PW1. PW1. Even the PN is also.
All right. Anything else?
Same thing is there. And
where is the impugned judgment?
yes, my lord. Here, my lord, another aspect, my lord. The report of the my lord, if I was challenged, my lord, and Central Food Laboratory judgment report came, but that was also not considered.
Sorry, I didn't get you.
My lord, first, my lord, the sample was sent to the food analyst. Food analyst report was against me. Then I challenged that report, my lord, under section 13(2). Then the sample was sent to the Central Food Laboratory. Central Food Laboratory report was also come.
Which
But
was in your favor?
not in my favor, but that was not considered. My lord, the conviction was made on the basis of the food analyst report only. My lord, your lordship may just see that.
The conviction is by order dated 3/7/13.
My lord.
2013.
13, my lord. And my food analyst sealed, my lord, till now, my lord, the entire sample has been. My first conviction is at page 22/12/10, my lord, by the Chief Judicial Magistrate, at page 18.
Page?
18.
Yes. This was the first.
Yes.
And then this was taken by way of an appeal.
Appeal, my lord.
That is at page 25.
Yes.
Where this ground was taken?
Yes. My lord, at page 7 and it's B, clause B.
Page?
Page 7, clause B, my lord.
No, not in the appeal memo. Before the appellate court.
Yes, my lord. Yeah.
According to you, this is a procedure, the violation of this procedural requirement is fatal to the
My lord.
prosecution
because
case.
Supreme Court has it mandatory. Our High Court judgment is also there, my lord. Just I can place one judgment at least. Recently, same thing, my lord. Same. Para 8 of this. Other infractions are also there, my lord. Rule 14 and other things are there. I am not going to that also. Para 8, my lord.
Para
8. From the premises of appeal to the non-compliance with the requirement 7 of the Act, correct perspective when it observed that the point whether the effort was made to satisfy the court, the genuine attempt was made to procure indemnities. The appellate court arrived at a finding that in the absence of any record there was doubt whether any effort was so made. The court therefore did not give any weight to the evidence of the police inspector and gave the accused the benefit of doubt and acquitted him. In my opinion, the view and facts have been allowing the appellate to arrive at the correct conclusion. There is no reason to interfere. Supreme Court has been relied on this, my lord, Supreme Court judgment. And the inspection report also it has not been shown, my lord. Because that they have to, they must show that they have made an attempt.
Yes, Mr. Goswami.
Record of inspection is there. Record of inspection.
Lordship, I am begging my pardon before Lordship that I have not a copy of petition, Lordship.
I
am begging my pardon before Lordship that I have no copy of the petition. I have not.
Yes.
And the LCR is also received here, Lordship.
LCR?
LCR is received here, Lordship.
Is received?
Yes.
Yes. LCR, yes, it can be seen, my lord, from the LCR, this is, my lord.
What is this, Mr. Sahaiwala?
This is the inspection report, my lord. In the inspection report, the food inspector has to mention, my lord.
Food inspector has to what?
Mention, my lord, that he has made an attempt, my lord, to...
That is not there.
Not there. He said, my lord, he asked the two persons to be...
That he has already stated in his deposition.
Evidence also.
That is an admitted fact that he has not made an attempt.
That is why, my lord, I am not going
Now
to...
the whole question is that whether because of that the entire trial is vitiated. That prima facie appears that there are decisions to that effect. Let us do like this then, and we'll keep it parted and we'll give a date. In the meantime, you have a look. You have you got the decisions?
No.
Please supply copy of these decisions to Mr. Goswami. You have a look at it. That is the only point which has been urged.
Other many points are there, but I am not going to...
Very well. So, only to that point,
yes,
if you have to say anything. When do you want this? Incredible. Yes, when? Hearing remains inconclusive. List this matter.
After vacation, 22.
22. 22. This bench will not be available. 2 weeks from 22. So have it before that, because otherwise I'll forget.
On 8, my lord? 9. 8 or 9? 9.
9. On 9/4/2024. किमान बोल 53 next what is there
Item number 57.
Inspector Vaidya, you are there?
Yes, my lord. My lord, this is an application for quashing of a FIR. Lordship, only on the primary technical parts and not into the merits of the case. Lordship, per se, my lord, this FIR is not maintainable in the eyes of law. In as much as, my lord, this has been initiated by means of a complaint petition filed before a magistrate under section 156(3). And, my lord, the mandate, as mandated in the Priyanka Srivastava case, my lord, that first the complainant has to resort to 154(1) and 154(3). That is the concerned police station.
154(1)
and 154(3), my lord, those remedies available to the complainant have to be exhausted. Subsequent to that, yes, my lord, the doors of the magistrate court are always open if the police does not pay heed to the complaints. So there is that violation, my lord. I will take your lordship to that. And secondly, my lord, this 156(3) complaint was made to a magistrate, my lord, territorial magistrate in Hojai, my lord. Whereas the offences alleged by the complainant contains section 13 of the Prevention of Corruption Act. My lord, a magistrate while exercising the jurisdiction and while applying his or her mind under 156(3), my lord, cannot direct investigation or cannot go to the extent of application of mind when a special act, the PC Act, or in other cases, my lord, acts may be concerned, where they specifically provided in the statute that, my lord, cognizance can be taken only by the special judge Assam, my lord, in case of Assam, designated court, which in our case is, my lord, the special judge Assam sitting at Guwahati, my lord. So, my lord, only on these contentions, I am not going to the merits, which of course, my lord, again, are speaking for themselves because exact same allegations, the complainant had filed a petition earlier. He is a so-called RTI activist. His demands were met. He did not pursue the matter. This very same complaint petition, my lord, both are annexed. Dicto word to word same complaint petition. He did not pursue. It was dismissed for default by camouflaging and
it got dismissed for
default, my lord. It is a part of the record, my lord. So that petition was dismissed, my lord, for not pursuance. And then again, my lord, he made demands to these public employees and contractors. Demands were not met. Same petition. He did not have the audacity, my lord, not to change a word here and there also. Same complaint petition immediately filed. And the magistrate, my lord, which has caused prejudice to the petitioners.
According to the magistrate, without application of mine, has taken cognizance.
Well, lordship, in case of complaint petition under PC Act, if it is filed on ignorance also,
the special designated court has to.
The complaint has to be forwarded to the special judge Assam. And the special judge Assam, yes, my lord, definitely can under 156(3) if no investigating agency pays heed to the complaint of a citizen.
Where is the complaint, Mr. Vaidya?
Yes, my lord. My lord, will give me a moment. My lord, the complaint is at page number 19, my lord. That is the starting of the present complaint.
Yes.
Which subsequently has been registered as an FIR. That's page number 17, my lord. That is the FIR covering page. This was registered as Lanka PS case number 105 of 98.
This is the FIR which you are seeking for quashing?
Quashing, yes, my lord. Yes, my lord.
Yes.
So page number 19, this is the genesis, actually. My lord, this is the complaint petition. This is the first page of the complaint petition. This was registered as 1050/2018, my lord. Here, my lord, would see that the complainant, number 1, Ajit Kumar Nath, number 2, are the accused persons who are the petitioners before your lordship now.
Name of accused person, MS Das is the petitioner?
Yes, my lord. Sujit Das. Sujit Das is the petitioner. It's
Sujit Das, represented by Suez.
Sujit Das, yes, my lord. Sujit Das.
But the accused is the Messrs. So-and-so, represented by Sujit Das.
Yes, my lord.
And who has filed this?
My lord, all the 4 persons, my lord.
They have filed
Gautam
it?
Das, Sujit Kumar Das.
They all have filed?
All 4, my lord. All 4 who have named. These 4 persons. Important point, my lord, page number 20, point number 3. Offences alleged.
Yes.
The substantive offences which have been alleged, IPC offences, alright, my lord, but section 7, 13, subclause 1, subclause C and D of the Prevention of Corruption Act, my lord.
Okay.
Here where the roadblock comes, my lord. For
PC Act, PC Act. Yes.
Yes, my lord. Now that being so, my
PC
lord,
Act, right.
prior to taking your lordship through the merits of the allegations, my lord, I am mentioning that in the 10 paragraphs of the entire petition, my lord, there is not a single avertment that the complainant, with the respondent number 2, had tried to lodge an FIR under 154(1) or had approached the superintendent of police under section 154(3).
About earlier, which got dismissed.
Yes.
That is not disclosed.
Those are not disclosed. Earlier petition to that lordship, that is a different aspect. That is a camouflage which he is attempting. Apart from that, my lord, before filing 156(3), for IPC offences also, my lord, today if I want to file a complaint petition under 156(3),
is there stay operating in this matter?
Yes, my lord. State is state.
No. Is there a stay operating in this matter?
No, my lord.
So what has happened after filing?
After filing, my lord, immediately we have filed a quashing as well as an anticipatory bail, owing to the nature that
What
the
is the
FIR
status of investigation?
Investigation, my lord, nothing has happened because there was no stay, because LCR has come also quite a while back, my lord, before this honorable court. Then again, a technical aspect took place, my lord, while listing the counsel for the petitioner, that is myself and my colleagues, names were not reflected, my lord, on one or two occasions. Fortunately, my lord, the matter is not dismissed. However, we could rectify that. Now the names of the engaged counsels are being reflected correctly. So that is why also, my lord, it took some time. Otherwise, we were keen on, my lord.
What is the main allegation?
Allegation is that, my lord, with regard to construction of two roads, my lord, some illegality was done by these...
Misappropriation of money.
Misappropriation of money, my lord.
And
Lordship,
who were these accused persons?
These accused persons, my lord, two of them happen to be the public servants, my lord. This
Junior
one
engineers?
My lord.
Junior engineer?
One junior engineer and one block level officer, my lord, of the block development office, my lord. My lord, to assess this honorable court,
Allegations are serious.
Allegations are serious, my lord, but the mandate of law has to be followed, my lord.
Which is the Priyanka case you are
Yes, my
referring
lord.
to?
Yes, my lord. My lord, first of all, I am providing this anticipatory bail order where the allegations are put, and 3 judgments, my lord, which I am relying upon.
What is this, AB?
No, my lord, this is a 482 application for...
No, this that you have handed over.
This, my lord, yes, my lord, that is the AB to all the...
What do you want to show from here?
Yes, my lord, the allegations have been briefed there in a nutshell, my lord, as well as there is an observation, my lord, that, my lord, the FIR, after going through the case record, that this is a brainchild
That
of the
observation is as regards considering your bail prayer.
Yes,
This
my
court
lord,
is
yes,
not
my
bound
lord.
by
Yes,
that
my lord.
observation.
Not
That is only for that
Only
purpose.
with regard to the allegations I am providing, my lord. Nothing in this bail order is binding on this court, my lord. Then, my lord, coming to Priyanka Srivastava's matter, my lord, this is the 2015 6 SCC.
Now, from where are you showing that this has been under 156.3?
156.3, my lord, it is in the cause title itself, my lord.
No, in the complaint.
This complaint, my lord.
You said it has been done under 156.3 instead of resorting under 154.1 or 154.3, correct?
Yes, my lord.
That was your
is
first
reflected.
submission.
Yes, my lord.
So
That
where
is
do we find that?
Yes, my lord. In the page number 16, my lord.
Page number?
16, 1-6, my lord.
1-6.
Yes, my lord.
Yes.
21/1/2019. This is the order of the learned magistrate, my lord. Complainant is present, hearty complainant. Peruse the complaint petition and the affidavit submitted by the complainant. On such perusal and keeping in view the nature of the offence,
Direct an investigation under
and the
156.3.
circumstances of this case, so magistrate has applied his mind. This court deems fit to direct an investigation under 156.3 of CRPC. Lordship, the matter on record is that the complaint petition has 10 paragraphs. In not a single paragraph, it is mentioned that an FIR was attempted to be lodged, that the superintendent of police...
This is not a writ petition.
Yes, my lord, but the mandate of law...
That you are making that submission, repeating that submission as regards disclosing all facts.
That is mandatory, my lord. In the complaint petition and in the affidavit, it has to be enshrined, my lord, that whether they have resorted to this remedy or not.
That is there.
That is there, my lord. That is
All
the
right.
mandate of
One
law.
by one, Mr. Vaidya. Let me first see 154.
Yes, my lord.
(156.3) is any magistrate empowered under 190 may order such an investigation.
Yes, my lord. That is very crucial. Empowered under 190. That is someone who is empowered to take cognizance of the matter in front of him or her.
upon receiving a complaint.
Yes, my lord. So 54.1 is to the police. 54.1 as your lordship stated, would start from there. That is to the officer in charge of a police station.
Yes, but it can be also a complaint. Here, what was it? It was an FIR.
Here it was a complaint, my lord.
Complaint.
Yes, my lord. Now, while explaining...
So the complaint is this, which is starting at page 19.
Is at page 19, yes, my lord.
Yes.
That is the complaint.
And so when a complaint is made, a magistrate can always take cognizance under 190.
Yes, my lord. A magistrate who is empowered to take cognizance can send this FIR for investigation, my lord.
Ms. Vaidya, I'm not being able to understand because two submissions you have made.
Yes,
one you have made is that one cannot directly resort to 156.3.
Yes, my lord.
One has to come either through 154.1 or 154.3.
Then exhaust 154.3.
This is one of your submissions.
That is one limb, yes.
Correct. Second, you are saying that since there are offences under the PC Act,
yes,
therefore there is a special designated court, and it is only that court alone which can take cognizance.
Yes, my lord.
And therefore the cognizance of the magistrate in this case is bad.
Yes, my lord.
One could have forwarded it. This is also another, correct?
Directive registration of an FIR.
Yes.
Suppose
now, as far as the first submission is concerned, this what does not being able to appreciate is because the section 190 clearly says that on a complaint file, the magistrate, if competent, can always take cognizance.
Yes, my lord. Yes, my lord. But the judicial magistrate first class at Hojai, my lord, in my most respectful submission, is not a competent magistrate who could take cognizance of an offence under the PC Act. And hence, my lord...
That is your second part. That is the second limb.
That is the second limb. In the first limb, my lord, that has been explained in the Priyanka Srivastava's judgment, my lord. To elucidate that...
Paragraph?
That is, my lord, paragraph 27, 28, 29, 30, 31, 35. My lord, specific lordship's query is addressed at paragraph 31, my lord, the penultimate page, my lord.
31?
Last but one page. The last paragraph, that is paragraph 31.
Yes.
Read. We have already indicated that there has to be prior applications under section 151 and 154.3 while filing a petition under section 156.3. Both the aspects should be clearly spelled out in the application and necessary documents to that effect shall be filed.
Alright.
In fact, my lord, the judicial dicta goes on to the extent, my lord, in this case, my lord, Priyanka Srivastava is a matter where two loanees, my lord, while being unable to repay the loans, had made this 156.3 complaint to pressurize the bank officials, my lord. And hence, my lord, there is an observation of the Apex Code that this has to be stopped. And so as to put the complainant under the bindings of law, it has been mandated that they will mention it mandatorily that they have exhausted the remedies under 154.
That is mentioned in Priyanka's, in this case.
Yes, but this paragraph says that it has to be 54 and 54.3.
No. That it has to be mentioned about exhausting the remedy.
Yes, my lord. This second line, my lord, both the aspects should be clearly spelled out in the application.
Or there has to be prior so and so while filing a
Paragraph 30, my lord, is the rationale as to why this direction has been made by the Apex Code, so as to avoid the misuse by complainants, my lord. Paragraph 30.
Yes.
My lord. So that mandate of law, my lord, in my most respectful submission, has been avoided by the complainant, my lord, which is respondent number 2. And in the affidavit, there is no such declaration that he has exhausted 154.1 and 154.3 and has directly, my lord, resorted to 156.3, which precisely Priyanka Srivastava Division Bench judgment wishes to stop, my lord. This is the first part of it, my lord. Now, coming to the application of mine, my lord, on receipt of this complaint, still, my lord, the magistrate could have sent it, my lord, to the Special Judge Assam, and maybe Special Judge Assam, after being satisfied, or the designated court, I should say, my lord, the designated special court after application of mine could have, my lord, ordered the registration of an FIR, maybe the special designated court would have been in appropriate court to verify as to whether 154.1 and 154.3 have been met with or not. My respectful submission is that the judicial magistrate first class at Hojai, my lord, could not have entertained this in the very first place. This, my lord, again, with regard to, there is a special act matter which I have placed before your lordship. Lordship, this Apex Court judgment of 2013-10 STC 705, my lord.
Yes.
Here,
Anil Kumar.
Yes. Anil Kumar, my lord, there's other aspect also, Anil Kumar versus MK Ayappa. Here, with regard to sanction also, the Honorable Apex Court speaks, my lord, as to whether sanction is necessary at this stage on even while directing the registration of an FIR under 156.3. I am not at that aspect, my lord. I am just placing one simple line of this judgment, my lord, at paragraph 16, my lord.
Paragraph?
16, my lord.
Yes.
The last line of page number 712. Now, who can direct this registration of this FIR or apply the mine? This paragraph 16. A special judge is deemed to be a magistrate under section 5 clause 4 of the PC Act. That is an accepted proposition, my lord. Therefore, clothed with all the magisterial powers provided under the Code of Criminal Procedure. Unlike a my lord, a murder case or 302 or 376, even though it cannot be tried by a magistrate court, but being a committing court, my lord, the court can remand, the court can apply mine, and after, my lord, the submission of charge sheet, the court can take cognizance and commit it. However, with regard to the PC Act, my lord, everything has been clubbed, my lord. The special judge or the designated court is a court of remand. When a court accused is arrested for the first time, unlike an IPC offence where he is produced before a magistrate who does not have the power of trying that accused, but still, my lord, other powers under the CRPC like 167, default bail, those are addressed by the magistrate. But when it's a PC Act, my lord, or for that matter of fact, my lord, other special acts, TADA, or then only the designated court has the power, my lord. That is what has been stated by the Apex Court, that a special judge or a designated court is clothed with all the powers of the magisterial court, my lord. So the remand and all the other powers would be exercised like taking cognizance, including taking cognizance under 156.3 or 190 CRPC for that matter, is vested with the designated court. I'll just read this paragraph only, my lord.
Yes.
A special judge is deemed to be a magistrate under section 5 clause 4 of the PC Act and therefore clothed with all the magisterial powers provided under the Code of Criminal Procedure. When a private complaint is filed before the magistrate, he has two options. He may take cognizance of the offence under section 190 CRPC or proceed further in inquiry or trial. A magistrate who is otherwise competent to take cognizance without taking cognizance under section 190 may direct an investigation under 156.3 CRPC. A magistrate who is otherwise competent to take cognizance without taking cognizance under section 190 may direct investigation under 156.3. But the magistrate who is empowered under section 190 to take cognizance alone has the power to refer a private complaint for police investigation under 156.3 CRPC.
What does this last sentence mean?
My lord, once the investigation is complete or a charge sheet is filed, to take cognizance, my lord, that is, now it is filed generally when the summons is issued or when cognizance that a prima facie case is made out that this is a suitable case for a trial, then if the magistrate has the power to take cognizance of a certain case under 190, then and there only we can equate that magistrate has the power to order investigation under 156.3. So a magistrate can exercise the power under section 156.3 to only those cases where that magistrate can take cognizance. Has the power to take cognizance if a charge sheet or if, my lord, the merits of the case.
Here in this case, the magistrate did not have power.
The magistrate did not have power, my lord. Under the PC Act, the magistrate does not have power to take the cognizance, my lord.
So at best he could have forwarded it.
Yes, my lord. Forwarded, provided, my lord, then, my lord, the other limb of my argument comes, my lord. Because if the special judge Assam was also approached, then, my lord, the criteria laid down by the Apex Court in Priyanka Srivastava would have not
But
permitted this to be proceeded.
now this is at what stage?
Investigation stage only, my lord.
Investigation
LCR before lordship, my lord. No.
So, can we not remand it to the magistrate court for doing proceeding in terms of law? Let him forward it to the special judge.
Yes, my lord. But then, my lord, the
This matter
registration
is
of this
pending
FIR has
since-
to be quashed, my lord. Then registration of this FIR has to be quashed, my lord. Registration of this instant FIR has to be quashed.
The complaint has to be forwarded to the special judge, and the special judge, after perusing, shall proceed in
Yes,
accordance with law.
If one proceeds, my lord, but register this Lanka PS case 105 of 2000.
If that is so,
No, my lord, I have a submission, Lordship. My lord, Bhojanland onwards, Lordship, the law is clear, Lordship.
Which one?
FIR, Bhojanland onwards, Lordship. When the FIR disclosed cognizance of
that is well settled. But
then it is not
Mr.
liable to be
Borwa,
set aside.
what the submission that they are making is about a procedural requirement.
My lord.
According to them, that cognizance could not have been done in law because it is the special court. Correct? Now that is a technical issue. If the magistrate court lacks that jurisdiction, then this registration itself is going to be bad.
No, my lord, for that, my lord, I'll take a lordship to my lord, Annexure 1, page 16. This is the order, my lord, which he is selling, my lord. Page 16, lordship.
Page 16.
16.
Yes.
Now, upon receiving the complaint, lordship,
Yes.
upon receiving the complaint, this order was passed, my lord, which he has been agreed, my lord. The complainant is present, heard the complainant, peruse the complaint petition and the affidavit submitted by the complainant. On such perusal and seeking, my lord, this is important, my lord. On such perusal and keeping in view the nature of the offence alleged and the circumstances of the case, this court deems fit to direct the investigation under section 156(3) CRPC.
There is no difficulty in this,
My
Mr.
lord,
Borwa.
my lord, my lord.
You have heard
Let
his
me-
submission.
my lord, let me complete, Lord.
Yes.
OC of the Lanka PH is directed to investigate the matter by registering a case under appropriate provision of law immediately. Send the copy of the complaint petition along with a copy of the order to the OC concerned, BA to do the needful. My lord, whether Lordship the magistrate court has taken cognizance? No. Now, my lord, Lordship will kindly see the, my lord,
The
complaint.
magistrate court has simply directed
But
the
no, only
investigator
directed the investigating officer to investigate. But the investigating officer may not find anything, my lord.
and that after at this stage itself, this case has been filed, and therefore that investigation did not progress.
They did not possible. I do not know what happened, my lord, in this case, because today I am appearing for the first time, Lordship. And my lord, whether my lord the OC has, my lord, investigated or submitted charge sheet, or investigating officer has, my lord, submitted final report, that is not known, my lord. Only, Lordship, he has directed the officer in charge to investigate the matter. He
Then
has
let
not
us
taken
have this
cognizance.
matter
If the
on another date. In the meantime, you get your instructions.
Yes, my lord, what is the outcome of the my investigation?
If you
now,
want-
if the court has taken cognizance, that would have been different, Lordship. The court has not taken cognizance. Only my lord simply forwarded the matter complaint to the officer in charge for investigation, Lordship.
Not simply
And
forwarded, my lord,
Lordship,
for
may kindly
registration
see,
of a case.
what are the section, Lordship? What are the section, my lord? It is not directly under the PC Act, my lord. First, Lordship, 420, 468, 409 IPC. Read which
bit.
section, Lordship? Read which?
No,
It
but
is not directly filed
that
under the
perhaps
PC Act,
the
Lordship.
moment red bit comes, then section 7 of PC Act gets attracted.
Yes,
So-
attracted, Lordship. But Lordship, when the magistrate has only, my lord, forwarded the complaint to register, my lord, where is the question of taking cognizance, Lordship? And how he has been agreed by this order, Lordship? And secondly, my lord, the informant is the necessary party in this case, my lord. Informant, my lord, he is not appearing today.
My lord, it
Whether
may be
he is
reflected,
aware
my
of the
lord.
case or not.
Earlier occasion he was present, my lord. Rather, my lord, for technical difficulty, the petitioner, my lord, myself, we were only absent, my lord. He is appearing regularly. Today, my lord, he is not.
Let the informant appear, Lordship.
We cannot force the informant to appear, but
his
what
name
can
has
be
been
done
shown
is that we can defer the hearing to another date. In the meantime, you also have a look at it.
My lord,
The LCR is reflected to be before your lordship.
Let him have a look at it. Mr.
Yes,
Borwa
my- yes,
hasn't
my
had the occasion to look into the LCR today, right? You have a look at it. But Mr. Vaidya, the counter argument that is coming forth is that the order dated 21/1/2019 is not a cognizance order.
Yes, ma'am.
That is an order whereby simply further the IO has been asked to investigate
Yes, ma'am.
and register
Yes,
a
ma'am.
case.
So registration
So
of the
that
case.
registration is not done.
Registration
done.
is done, my lord.
The registration is done, Lordship. When the complaint is forwarded, my lord.
That registration is done when?
This, my lord, subsequent to this order. On
Subsequent to
15/3/2019,
this order.
Yes, my lord. This is now Lanka PS case 105.
No, it is the duty of, my lord, when a...
One second.
complaint
You both submit together.
Let my
When a
learned senior,
complaint is forwarded to the officer concerned, Lordship, officer is concerned, that he is bound to, my lord, register a case, Lordship. Then he will investigate.
So now, let me understand. Now, once a complaint has been sent under 156(3) for further investigation and registration, thereafter the investigation officer will have to investigate and see what are the materials. Accordingly, a case will be registered, prima facie, and thereafter send a report back. Based on that report, a cognizance has to be taken. Correct?
May be taken or may not be
May
taken.
not be
also.
taken. That's why I'm
Because
saying
if
based
the-
on.
if the
So now that
investigation-
the third stage has still not come.
Not come, Lordship.
Has not come here.
Then how he is aggrieved by this order, Lordship? And secondly, Lordship, the investigating officer may not found anything under the PC Act, Lordship. Then
No, the investigation officer's report is not available. Otherwise, registration is done under PC.
Registration is done on the PC Act, my lord.
Registration is done.
Yes, my lord.
Only thing,
Registration
Mr. Borwa, you do one thing. You find out if a report has been prepared.
My lord, we peruse the scan copy, Lordship. What
You
is-
have a look at it. When should we fix this?
Lordship, just one aspect, my lord. What Lordship had stated that my learned friend is trying to probably interpret or impose, my lord, is that 190 CRPC is taking of cognizance. And 156(3) probably he is stating.
Correct,
and to a
investigation.
certain extent, It's a pre-cognizance stage also.
Correct.
That he is saying that where am I aggrieved? Because cognizance, he is not taking cognizance. He is just directing investigation. That is why, my lord, I placed this judgment, my lord, this MK Ayappa judgment before your lordship.
It's all right. This court will look into the matter. We are hearing. We're just deferring the hearing to another date to enable the public prosecutor to have a look at the LCR.
Yes, my lord. Yes, my
When do you want it?
That will be after vacation of the mother view.
Date?
23 or 24.
Hearing remain inconclusive. List on
23 or 24.
20.
Let it be on to 25th of hearing them.
25? 25 or 24 for further hearing. We shall keep these case laws, Mr. Vaidya.
Yes, well. Yes, well. Keep your break,
8. Oh, that's.
What is this?
May I please, Your Lordship, today I have filed one additional affidavit, Lordship. Lordship, kindly let me be produced, Lordship.
Additional affidavit khana hai nahi? Has the additional affidavit come?
That the deponent is the...
It's not come.
It is in the record, Lordship, probably, Lordship.
No, it has not come. We posted on Monday. Your name?
Ayu Chaudhary, Lordship.
Mr. Ayu Chaudhary, Learned Counsel for the petitioner submits that an additional affidavit has been filed on
Today, Lordship.
filed on today, IE 28/3/2024. Stop. However, the same is not available on record. Let the registry verify and place the same on record. List on Tuesday?
Lordship, Monday, Lordship.
Monday?
It was, Lordship,
Okay,
the-
Monday.
Lordship.
All right.
Obliged,
Item number 58.
Please, Your Lordship. Yes, please, Your Lordship. Lordship, kindly take up this matter on Friday, Lordship. Today there is some difficulty.
You are?
I'm appearing on behalf of Mr. Vice Mandan. and
Your name?
N. Dekaraja, Lordship.
As prayed for by MS?
N. Dekaraja.
N. Deka, Learned Counsel for the petitioner. List this matter. Yes, Mr. Borwa?
Any that, Lordship. The hearing matter was
On when?
On Lordship, Friday, on 5th.
Friday is not a hearing day.
after vacation also. So before Bihu also there will be a
After vacation?
Lordship, immediate after Bihu vacation.
Did you on 19/4/2024.
Okay, 19.
Next.
Much obliged, Lordship.
Number 59.
Yes, Mr. Gogoi.
My case is a jail appeal. Right, order last order, my lord's informant was issued notice.
Served.
Informant was issued notice to the Legal Service Authority. The POCSO convicted, my lord.
Yes. Nothing has come. Monday.
Item number 60.
Petitioner? Yes. Yes, Mr. Roy.
Today fixed for
Mr. Roy?
today is fixed for hearing of the stay vacating petition.
Stay vacating petition.
Lordship, both sides have exchanged their affidavit. So entire criminal division petition quashing may be heard. There will be
On another date then.
No,
The entire petition can be heard next week.
It should be vacated. 8 months it has been going
All right.
on.
The pleadings
It's
have
my
been
humble-
completed.
it's my
Criminal
humble prayer.
petition is ready for hearing, right?
yes, all affidavits. have been
Tuesday. I'll post it for hearing. It is submitted at the bar that the criminal petition is ready for hearing as pleadings have been completed. Stop. Considering the urgency of the matter, list this matter on Tuesday. Date to dia.
Second.
2/4/2024 for final hearing of the criminal petition along with all the connected interlocutory applications.
Item number 61.
Lordship, in this case, the issue is simple, but one report was called for, report has not perhaps come.
What report?
However, Lordship,
What report was called?
Excuse me, Lordship. Lordship, in item 60, interim may continue.
Interim order passed. Any may continue.
Obliged. Lordship, report in regard to that IO has filed a charge sheet without naming
Is the report available?
Not received, Lordship. Not
Await report of the IO as per as called by order dated 31/2024. Stop. List on.
I have a pair, Lordship.
Let the report come. List on. Yes. When can the report be produced?
19/4.
Lordship, 19, that my next date is also coming. It is the
Here.
Lordship, the appearance someone has been received by the petitioner.
So you have it before the Bihu.
Before
next date, yeah.
Next date 19.
19. So 10/4.
10/4. Yes. Next.
Item number 62.
Lordship, before then, okay. The 10 is the last date, Lordship. Before verification.
So 9.
9 corridor. Yes.
May it please your Lordship? Lordship, I kindly pray before you to for the mediation, Lordship, among the parties.
You want to explore mediation?
Yes, Lordship.
As wishes of the petitioner side, my lord.
Sorry?
My lord, I have no objection.
This is otherwise what? What is the matter?
This is 482 quashing, Lordship, of the domestic violence filed by the wife against her husband.
All right. This is the matter which you wanted to mention in the morning. You are making a mention in.
Yes, my lord.
All right. So I'll refer it.
Yes, my lord. That may be fixed, my lord, for mediation.
Yes. And item 62. You are
Miss A. Bora.
heard MS A. Bora, Learned Counsel for the petitioner. Stop. Also heard
B.R. Sultana.
MS B.R. B.R.A. Sultana,
Yes, ma'am.
Learned Legal Aid Counsel for the respondent.
Respondent. Yes, ma'am.
For the respondents?
Yes, ma'am.
For the respondents. Stop. It is submitted at the bar that an attempt may be made for amicably settling the issue involved in the criminal petition through the mediation center. Stop. Accordingly, let the records of the criminal petition be placed before the Guwahati Mediation Center, whereafter a mediator shall be appointed, and who shall thereafter explore the possibility of settling the matter. Stop. Let the exercise be completed within a period of 2 months, 1 month,
1 month.
1 month upon receiving the records of the case. Stop. List after 1 month on a date to be